Good morning. This is the September 27th, 2023 Colorado Energy and Carbon Management Commission business agenda. We will start with roll call.
Thank you, Mr. Chair. Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Misner.
Here.
Commissioner Oath. Commissioner Ray.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present.
Great. Good to see everybody. Got a full docket. We'll roll right into it. We start out with an opportunity for commissioner comments. Does anyone have comments? Seeing no comments, we roll into consent agenda with 3 hearing officer recommendations under Rule 505. Is there any questions on consent? Seeing none, do we have a motion to approve consent?
So moved.
Second.
Motion and a second to approve the consent agenda. All those in favor signify by saying aye. Aye.
Aye.
Great. Rolling right along here. We now will turn to docket 230700241. This involves an enforcement default. The applicant is our staff, and it involves the Barry Walter 5 DBA Barry Energy Incorporated, operator number 8005. I believe we need to elevate our hearing officer and our enforcement officer. Hello.
Good morning, everybody. If it's all right, I'm going to also share my screen. I have a little presentation for everyone.
That sounds great.
Okay. Can you see that?
Yes, we can. It's not in presentation mode.
Nope, I will move it into presentation mode. All right. How's that look?
Looks great.
Fantastic. So thank you all for your time this morning. My name is Sierra Schroeder, and I am an enforcement advisor with ECMC. And today I'm here to talk with you about the Barry Walter Energy Group. They do business as Barry Energy, so that's how I will refer to them throughout the presentation today. And we are going to talk about an order finding violation against them and then potentially moving their wells into the orphaned well program. So I always find it helpful to start with a little bit of background so that you know who they are. The Barry Energy Group owned and operated over 70 wells across 4 different counties in Colorado. That'd be Kiowa, Adams, Prowers, and Washington County. But all of their wells were plugged and abandoned between 1983 and 2011. They do hold financial assurance with the state. Based on this slide, it might look like they have $120,000 in financial assurance. It's actually only $60,000. Their final surety ID for the 2010-143 is just a combined bond of the previous 2 bonds. So it's a total of $60,000, not $120,000. That can get a little tricky. And then I also think it's helpful to understand what rule we're going to be talking about today. So I'll explain it a little bit and then just keep it in the back of your mind as we move forward through the presentation. Rule 1004A requires an operator to backfill all pits and mouse and rat holes upon the plugging and abandonment of a well. It also requires the operator to remove all debris, surface equipment, abandoned gathering and flow line risers, etc. within 3 months of closure of the well. Any other equipment, supplies, weeds, rubbish, waste materials must be removed within 12 months of the well being plugged, as well as final reclamation completed within 12 months. So it's 3 months for a few things and then a year for pretty much everything else. And then moving into more of what happened in this case and why we're here today. In 2021, February 2021, ECMC staff went and conducted an inspection of 2 of Barry Energy's wells, the Bailey's Inc. well and the Fanny B well site. Both of these wells were plugged and abandoned on June 11, 2008. But when staff went out to go see the Bailey's Inc. well site, they found abandoned and unused pipe risers and that uniform vegetation had not been established. And then at the Fanny B well site, they found that there were soil piles that had not been recontoured or reclaimed, pits had not been backfilled or reclaimed, and there was a pit liner on the site that had never been removed. After submitting their inspection report, they went back out about 9 months later in November and found that there had been no changes to the site whatsoever. And so then on February 9th of 2022, staff issued 2 NOAVs against Barry, one for the Fannie B well site and another one for Bailey's Inc. And both of these NOAVs cited violations of Rule 1004A, recalling that 1004A required reclamation to be completed within a year, and for all of those pipe risers and pits to be backfilled within 3 months. So since the wells had been plugged and abandoned in 2008, that should have been done much sooner than 2022, which is why the NOAVs were issued. So then some procedural history here. After the NOAVs were issued, we noticed this matter for hearing in July of this year. We then published that notice in all of the local newspapers where Barry had done business, as well as in Denver as required by the rules. We also mailed the notice to the address on file for Barry. However, that notice was returned to us on August 21st as undeliverable. The NOAV, when that was mailed to the same address, was also returned as undeliverable, and there was no forwarding address available. We also tried to email the notice to the principal agent to the email address on file. That also bounced back as not deliverable. So then we tried to call the number on file for the principal agent and left a voicemail. We didn't hear back, so then we tried to email the other email address on file, but again, we did not receive a reply. And so then we tried to call the principal agent one more time and left another voicemail. We also called the other number that was available on file, but that phone number had been disconnected. We did, however, about 2 weeks ago, receive a phone call back from Mr. Art Pansy, who I believe is listening in today. And I was able to call him and just talk with him a little bit. And he used to work for Barry, but he explained to me that he had sold all of his interest in the company to somebody else, and that he had not been a principal agent of Barry, so his phone number was listed incorrectly on the website. He gave us the information to call the man who was the principal agent and to whom he had sold his interest, Mr. Mike Cruson. However, when I called him, he asked that we send him a letter with all of this information. I asked for his email address, which he did not provide. So then I asked for his home address, but before he gave it to me, he had hung up the phone. So it didn't seem like he was too keen on participating in this matter. Art did inform me that he also told Mike about the hearing today and that it didn't seem like he was going to be participating. So we made a lot of effort to contact Barry Energy and their employees, but to no avail. So we moved forward and went ahead and calculated a penalty. This was a Class 2 rule as per the ECMC penalty guidance. And it's a moderate impact because they failed to reclaim, which does have lasting impacts on the land, as well as leaving open pits that poses a threat to anybody who might walk onto the land. So this came out to a $326,620 penalty. And then we are asking the commission to grant our proposed order and direct the director to suspend Barry's Form 10s, terminate their operator number, rescind their Form 1, revoke their authorization to conduct oil and gas operations in Colorado, and foreclose their existing financial assurance. We are also requesting that the commission direct the director, using her discretion, to declare Barry's wells as orphaned wells, use funds from the Energy and Carbon Management Cash Fund to investigate, prevent, monitor, or mitigate conditions that threaten to actually cause adverse environmental impacts, and claim all of Barry's equipment and saleable product as property of ECMC. That is all the information that I have for you today, but if you have any questions, I would be happy to answer those.
Thank you very much, Ms. Schroeder. Do commissioners have questions? Commissioner McGowan, then Commissioner Ackerman.
Thank you, Mr. Chair, and thank you, Ms. Schroeder, for your presentation. And I guess this is just a little disappointing or alarming. I don't know which word to use. You might not know this answer, but are the majority of these wells already shut in, or are they producing
No, as far as I'm aware, they have all been shut in. So we would just have to do reclamation.
Okay, I think this is not your fault, or this is not your fault. I'm just going to preface this by, I think I'm concerned that it took us this long to figure out that this operator was in the situation that they're in and maybe hasn't been doing anything with their wells potentially since 2008. It's unclear to me if we have inspected other of their sites or if we've just not gotten around to their sites. And I'm very appreciative that you tried everything in your power to contact somebody who might be in a position of responsibility for the operator. So thank you for doing that. I think that's gotten us sideways in a couple of cases in the past. So I'm supportive of what staff is recommending here, and I appreciate your due diligence.
Thank you.
Commissioner Ackerman?
Thanks, Mr. Chair. I think Commissioner McGowan addressed my question largely, but are there other, are we aware of these other, the status, the reclamation status of the other wells that he has? Have we inspected them all? Kind of, can you elaborate on what the status is? Are all of them in similar condition to these, or have there been some that have been properly reclaimed?
I'm not sure on that right now, but I would definitely look into it and I can get back to you all with a follow-up email with that information.
Thanks, I appreciate that. And are you aware of, Commissioner McGowan touched on this, when these were P&A'd originally, are you aware of what procedure took place from COGCC at the time?
I don't know that either, but again, I would be happy to follow up on that and send you guys some more information.
Okay, thank you. I'm supportive of this action as well. I do think if staff hasn't examined the procedure that led to the 12.5-year lapse here, we should do so immediately, but I'm presuming that we have and are addressing it. Thanks.
Further questions? Seeing no further questions, I'm in agreement with my fellow commissioners. I believe we need a motion to approve the order finding violation.
So moved. Second.
Motion and a second.
We have AAG Davenport.
AAG Davenport, please.
Thanks, Chair. And I just noticed something, and it's entirely possible that I missed this. In my review of the proposed order, I did not, the order section that starts on page 8, I did not see a specific direction to Barry to pay the penalty. I recognize that in this situation that may be unlikely, but perhaps staff has a reason for that omission or can direct me to where I missed it in the order itself.
Yeah, we did not include a direction to pay the penalty because we hadn't heard from them. So we just assumed that they were non-existent. And then in talking to some of the employees, it's our belief that they wouldn't even have any funds to pay the penalty. So that's why we did not include it in the order.
AAG Davenport, normally, I think we have the direction to pay, and then there's a period of time, and then if payment is not made, then the other penalties come into being. Is that your thought, or is that where you're going?
That is, I think, standard language in this situation. I think in this case, what I recommend is just adding a paragraph to the order, and this is purely out of an abundance of caution, that directs Barry to pay the assessed penalty within, I think the correct time period is 30 days of emailing the order to them.
Okay, we'd be more than happy to add that to the order.
And then the follow-up is that if payment is not made, then the director is ordered to do A, B, C, and D.
Yes, I think that's the standard language in this case. I wonder if there's a reason that staff did not want to wait for that time period to pass.
Not that I can think of. Like I said, we'd be happy to just add that into the order and send a revised order or submit a revised order.
Okay, then I think that is the order of play. Commissioner Messner, yeah, I've got you. Give me a sec. So let's make, let's see, we had a motion and a second. Is the movement okay with the change?
Yes.
And the second is okay as well. Further discussion, Commissioner Messner?
Thank you, Mr. Chair. I may suggest an additional change because in my recollection, typically in a situation where we're potentially removing an operator's ability to operate and certificates of clearance, that there would be a provision should they come before the commission to request the ability to be able to operate in the state of Colorado again, that payment would also have to be paid prior to any consideration of that request. And so at least I'm used to seeing that in recommended orders like this. And so I don't know if that's something, AAG Davenport, that you would suggest be included as well.
Mr. Chair,
Yeah, go ahead.
thank you. Good suggestion in my view, Commissioner Messner, and as long as staff doesn't have an objection, I think the motion can include instruction to include that provision in the order as well.
No objections
Sure.
from staff.
You're okay with that?
Yep.
Okay. I think consistency makes some sense here. So one last question to the movement. You okay with the second friendly amendment?
Yes, Mr. Chair.
And I see that the seconder is also okay. So we now have a motion with two amendments that would be our entrance of the order finding violation. Is there any further discussion? Commissioner Cross.
Thank you, Mr. Chair. And I'll just say I'm in agreement. I think the one other thing that I'd like to point out for those listening in as well is it's also a little frustrating that for someone to transfer their rights in some of these, but not make sure that anything is filed with the commission is also problematic. I think that should be something that they focus on doing so we can make sure that the right person is found and kind of behooves the person that is selling their interest as well as helping the commission in matters such as this. So I just want to make sure that that's pointed out as well.
Very good. Other comments before we act on the motion? Seeing no further comments, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. Thank you, Ms. Schroeder.
Thank you all.
All right, moving right along, we will move to docket 2309000279. This is a variance request from Carence Piance LLC. And I believe we've got Ms. Waslinki. Good morning.
Good morning, Chair. We will
You,
admit our panel, if that's okay.
yeah, that's great.
And if we'd like to do the swearing in at the outset, we'll make sure the whole team is on and we can do that.
Very good. Got AAG Davenport ready for some swearings.
And if everyone from the Karis team could turn their cameras on. Let's make sure we've got everybody. Let's see. I think,
What about Mr. Krosky? Is he with you?
let me see. Tim is here. I think we have, we've got everybody. Yep. Oh, Mr. Krosky is just screen sharing, so he's not on the panel.
Okay, great.
Wonderful.
AAG Davenport.
Okay, thank you, Chair. Thank you, Ms. Waslinki. To the witnesses, what I'm going to ask you to do in turn is please to raise your hand, state your name, and say that you swear to tell the truth. I'll just go in the order that you're appearing on my screen. Ms. Lingley.
Kristen Lingley, I swear to tell the truth.
Thank you, Mr. Bear.
Tim Bear, I swear to tell the truth.
Thank you. Ms. Beeson.
Aubrey Besant, I swear to tell the truth.
Apologies for mispronunciations.
No problem.
Ms. Ryder.
My name is Lindsay Ryder, and I swear to tell the truth.
Thank you, Mr. Yancey.
I swear to tell the truth. My name is Lindsay Ryder, and I swear to tell the truth.
Thank you, Mr. Yancey. Ms. Beeson. Aubrey Besant, I swear to tell the truth. Thank you, Mr. Yancey.
My name is Alex Yancey, and I swear to tell the truth.
Thank you, Mr. Kistner.
Kurt Kistner, I swear to tell the truth.
Thank you, and Mr. Middleton.
Middleton, I swear to tell the truth.
All right, thank you all.
Great. With the procedural formalities out of the way, we will allow you to proceed into your case in chief.
Thank you. We will bring a PowerPoint up and then I'll get started. Wonderful. Well, good morning, commissioners. My name is Kelsey Waselinki with Jost Energy Law, and with Jamie Jost, we represent Karis Piance LLC in the variance application before you in docket 2309-00279. On behalf of Karis, we would like to extend our thanks and appreciation to the ECMC OGLA permitting and hearing staff and the director for their efforts on this variance application. We would also like to thank the BLM, CPW, and Rio Blanco County for their consultation and support of the variance application. I'll start the presentation today with an introduction to the Karis team, an overview of the variance application requests. We will show a short drone video of the 2 access roads subject to the variance application and an overview of the legal standard of review before I turn it over to Karis to walk through the Rule 502C elements. Next slide. Karis has a team of subject matter experts on the hearing today, and they are listed here. As you can see, there are subject matter experts in the areas of land, engineering, operations, EHS, and regulatory, and we look forward to answering any questions you have at the conclusion of the presentation. As a quick overview of the company, Karis is a privately held company with substantial leasehold in the Piance Basin. Karis operates approximately 4,800 wells with the recent acquisitions of Encana, XTO, and Berry Petroleum. The variance application requests relief from certain 300 series rules only as such rules apply to the construction of 2 access roads before the RNPU Phase 1 OGDP is heard by the Commission. These 2 access roads are defined here, and we may refer to these roads as the B27 and the A27 access roads. The B27 is the drilling pad, and the A27 is the Central Delivery Point, or CDP, which is a proposed shared facility for the B27 and future pads. The access roads were submitted as part of the RNPU Phase 1 OGDP application, which was filed in April of this year and is currently pending a completeness determination with the ECMC. In short, the variance application requests that the Commission approve the 2 access roads before hearing the RNPU Phase 1 OGDP so that Karis can construct the access roads outside of several HPH timing stipulation windows and prior to a federal unit obligation spud date, which Karis will fully describe to you today. This map is a very simplified visual of the access roads as they relate to the 2 proposed oil and gas locations that are subject to the RNPU Phase 1 OGDP. Both roads feed into County Road 5, shown on this map, in a very remote area of Rio Blanco County. The surface of the access roads is owned primarily by the BLM and a portion by Karis. The access roads fall into several high-priority habitats. Portions of the access roads are within 500 feet of aquatic HPH, which CPW has waived. The access roads also fall into Rule 1202D Big Game HPH, and Karis agrees not to construct the roads between December 1 and April 30. There are 3 observed golden eagle nest sites within half a mile of portions of the proposed access roads, and Karis agrees not to construct the access roads between February 1 to August 31 or until the birds have fledged. And again, we'll fully address the applicable HPH in the presentation today. In order to fully describe the location of the 2 access roads, the complexity of construction, and the geographic isolation of the area, we thought it would be helpful to show a drone video flying the length of the access roads to each proposed location. You will see the vegetation, terrain, and proposed pad locations, and we'll go ahead and play this now. So the video starts with the A27 CDP access road and the entrance off of County Road 5. The A27 CDP would be located in the valley of Lee Gulch, which was found by CPW to not meet the definition of aquatic sportfish management waters. Here's the dry ephemeral channel Lee Gulch, which is also used as a 2-track road to access BLM lands. Now we'll see a view from the A27 location back to County Road 5, running the length of the access road. And now we'll move to the B27 access road, which is shown on top of this ridge line. And here the video shows the B27 road to the location. And here's the proposed B27 location. Great, thank you. We'll now move to the next slide. So moving on to the standard of review, the variance was filed under Rule 502C, which contains 5 elements that CARES must demonstrate for the variance to be approved. We'll walk through each of these elements and how CARES meets each one in the presentation today. Prior to filing the variance application, CARES worked with ECMC hearing staff to generate a list of 300 series rules that apply to the variance. I will walk through these briefly. The first rule is 303A2, which provides that an operator cannot commence operations at an oil and gas location without an approved Form 2A. The access roads are a part of the 2 submitted Form 2As, which again are subject to the RNPU Phase 1 OGDP. The variance requests approval to construct the access roads prior to the Form 2A and OGDP approval. The second rule is 304A, which requires that operators submit a completed Form 2A as part of an OGDP. CARES will still move forward with complete Form 2As as part of the RNPU Phase 1 OGDP, but requests approval of the access road component prior to the OGDP hearing. The third rule is 304B7F, which requires that a Form 2A contain an access road map. Again, CARES will still move forward with complete Form 2As as part of the RNPU Phase 1 OGDP, but requests that the access roads be approved prior to the Form 2A approval. The fourth rule is 306A1, which provides that the director cannot make a recommendation on an OGDP until she has reviewed a full and complete OGDP. CARES requests that the Commission consider the director recommendation for the approval of the variance for the access roads prior to the full OGDP hearing. And finally, the last rule is 307A, which provides that upon receipt of the director recommendation, the Commission will consider the OGDP. And again, CARES requests that the access road component of the OGDP be reviewed and considered ahead of the full OGDP hearing. So before I turn it over to CARES, I wanted to walk through how CARES came to submit the variance application. CARES filed the RNPU Phase 1 OGDP in April of 2023. The OGDP application includes a description of the HPH timing stipulations and overall development plan for the federal unit, highlighting the unique nature of Piceance Basin development timing. In July of 2023, CARES did attempt to communicate with ECMC permitting staff to inquire on the timing of the OGDP review. I do want to reiterate here that CARES places no blame on ECMC staff for the timing of review of the OGDP. CARES is deeply appreciative of staff's time commitments and workload, and fully appreciates that both ECMC staff and operators have and continue to learn through the OGDP process. The RNPU Phase 1 OGDP is CARES's second OGDP submittal, and it has been a good learning experience for CARES. Kristen Langley and Alex Yancey can speak to these learnings and new systems in place for future OGDP submittals if you have questions about this. So when it became apparent that CARES may not receive completeness review and a noticed hearing date for the RNPU Phase 1 OGDP in time to complete construction of the access roads prior to the federal unit spud date, CARES had a few conversations with the OGLA staff to discuss the status of review of the OGDP and a possible completeness date. In addition, CARES discussed the possibility of a variance application with the ECMC staff. Karis decided to move forward with the variance application only after consultation with the BLM, CPW, and Rio Blanco County, who all voiced their support or non-objection to the variance application. The agency consultation summaries and written waivers are included with the variance. Karis also had a virtual meeting with the lead OGLA and hearing liaison to discuss the variance application and request prior to filing. And on August 30th, Karis received its first set of completeness comments from the OGLA staff for the RNPU Phase 1 OGDP. And on August 31st, Karis filed the variance application, knowing that even if OGDP and completeness and a hearing date could be determined in a matter of days, Karis would still miss the construction window for the access roads before the federal unit obligation spud date if the access roads remained part of the OGDP. On September 7th, Karis resubmitted the RNPU Phase 1 OGDP, incorporating staff's feedback. And as of today's hearing, the OGDP has not yet passed completeness. I will now turn the presentation over to Kristen Langley with Karis to provide a status update on the federal APDs and to walk through the 5 elements in Rule 502C.
Good morning, Commissioners. Kristen Langley, Director of External Affairs with Karis. Due to the federal surface and minerals that are proposed to be developed through the RNPU Phase 1 OGDP, Karis is concurrently permitting these 2 locations through the BLM and ECMC's OGDP process. We do not foresee any issues with the approval of the federal APDs expected by September 30th. The BLM provided an email update on the federal permit, which we submitted as Exhibit C. As of today, we have not been made aware of any major issues with the environmental assessment or federal APDs, and the BLM has approved Karis to construct the access roads after the APDs are approved. The first element that Karis meets for this variance is a good faith effort to comply. As we explained in our application, Karis submitted this OGDP in April in hopes of receiving approval by October, even with some wiggle room. We based our estimated timeframes on readily available public information on previous operator submittals and ECMC's rollout of their new enhanced completeness process. Karis acknowledges that we could have provided more detailed justification of the unique timing challenges we face in the Piceance Basin in our OGDP submittal and in subsequent correspondence and outreach to staff, and we commit to this greater communication on pending and future OGDPs. In order to describe the thought process that went into the timing of Karis's OGDP submittal, I thought it might be helpful to summarize how Karis relied in good faith on an expected October OGDP hearing date. The timeline on the chart on the right lays out our submittal justification based on the ECMC staff guidance rolled out in March of 2023 and our estimate of no more than 90 days for the OGDP to receive a completeness determination. As you saw in the drone video, the road will require at least 6 weeks of solid days work. Pad construction and subsequent mobilization add several weeks to that timeframe. If the variance is denied and the roads cannot be constructed in 2023 due to high priority habitat timing stipulations, Karis will not meet our federal unit obligation spud date of October 26, 2024, if the construction window does not exist this year. Kurt Kistner is Karis's construction and operations expert. He's here today to answer any questions. Another aspect of the good faith effort to comply standard is securing of waivers from interested parties. As a part of this application, we consulted with BLM, CPW, Rio Blanco County, and Karis as a surface owner. We also met with ECMC staff prior to submittal of the application. No objections to improving the construction of the access roads or shortening of the hearing notice were stated, and these parties specifically waived their petition and the right to petition the variance application and affirmatively did not object to the requested relief. The applicable waivers that were obtained can be found in Exhibit B and summaries of those consultation summaries in Exhibit E. This slide summarizes the results of our consultations with CPW, BLM, Rio Blanco County, Karis as a surface owner, and ECMC staff prior to filing. It's important to note that Taylor M, North West Region Energy Liaison, summarized the CPW consultation to ECM staff and represented that from a wildlife perspective, CPW supports this approach so that Caris does not need to seek relief from the seasonal timing limitation. The approach referenced by Mr. Elm is a construction of these roads in the fall outside of the seasonal timing limitations for high priority habitat. Lindsay Ryder, our director of EH&S, is here and can answer any questions regarding our wildlife conversations with CPW and BLM. An important part of the need for the variance today is the undue hardship Caris will face in losing thousands of prospective acres if we're unable to meet our federal unit drilling obligation. We received a few commissioner questions regarding how long Caris has had the federal unit obligations in place for the Phase 1 OGDP, Mineral Development RNPU area agreement, what the process is for asking for said extension, and whether Caris considered asking for an extension from BLM. I will now address these questions. The original federal unit drilling obligation spud date under XTO's ownership was October 26, 2020. However, due to the COVID-19 pandemic, XTO requested a suspension to the drilling obligation, which was granted by the BLM, extending the spud date from October 26, 2020 to February 2022. Caris acquired this asset in July of 2021 and immediately requested a second extension and amendment to our RNPU unit agreement from the BLM, knowing that the February 2022 obligation could not be met due to permitting and construction timelines. The process for obtaining the second extension and amendment to the RNPU unit agreement was extensive and comprehensive, which included a multidisciplinary team at Caris, as well as multiple personnel from both the field and state BLM offices. The B27 pad is the first location selected to meet drilling obligations spud date due to its proximity to existing infrastructure, thereby reducing Caris's footprint and ground disturbance. Caris's step-out development approach played a large role in BLM granting the Second Amendment and extension, as it drastically reduces the surface disturbance, allowing for more wells to be drilled from fewer locations. Caris began multiple agency on-site reviews for this drilling location and corresponding CDP in September of 2022. From that point forward, Caris progressed the OGDP with an April 2023 submittal in hopes of securing construction for this fall. We have actively been working the regulatory process since receiving our federal unit extension and corresponding unit agreement amendment. The October 26, 2024 obligation date is the extension date that was granted by BLM to Caris. Aubrey Besant, our Vice President of Land, can speak more to these negotiations with the BLM and our unit obligation if you have additional questions. One of the unique challenges and opportunities to protect we face here as an operator in the Western Slope is the diversity of big game, golden eagles, aquatic species, and the potential for migratory birds. The associated timing stipulations leave for a very limited 3-month construction window for our roads and pads from August 31st to December 1st. As a responsible operator, we want to find ways to avoid potential impacts, and one of those strategies is to avoid construction and work with heavy equipment in seasonal timing windows. We believe that constructing the access roads this fall is the prudent and responsible practice to avoid potential impacts to big game during the winter and the golden eagle nesting period in the spring. We have successfully deployed this strategy in consultation with CPW and BLM on previous development projects. And as we mentioned, CPW supports Caris constructing the access roads this fall to maintain the high priority habitat timing stipulations. Another element of undue hardship relates to our drilling rig contract. We were able to secure this rig from North Dakota in 2022. We've made multiple rig enhancements and taking a considerable amount of time to ensure that the crew can safely operate in the unique landscape of the Piceance Basin. If the 2024 drilling window is missed, the rig will be demobilized off of Caris acreage. There will be resulting impacts to workers, and we would lose the highly trained rig crew. Tim Bear is our VP of Engineering and can answer more questions on this matter. This slide explains the scenarios for access road construction aligned with the wildlife stipulations if the variance is approved or not approved. Scenario 1 contemplates the variance and OGDPs both being approved. As you can see, this scenario ensures that the access roads are constructed by December 1st, allows for a pad construction window either in May to July or in September of 2024 if an eagle nest is occupied, ensures the federal unit spud date is met by October of 2024. Scenario 2 assumes the variance application is denied, the OGDP is approved, and there are birds occupying a nest. Nest occupation is most likely scenario given our 2 seasons of observations of the 3 known nests. This means construction can't start until September 1, and Caris would need to construct the roads and pads simultaneously. In this scenario, Caris will not meet the October spud date, considering the time needed for rig mobilization and at least 6 weeks of continuous construction. Caris agreed to multiple BMPs and timing stipulations as it relates to protecting the one sensitive receptor in the area, wildlife. It is important to note that none of the Form 2A plans or attachments provided as part of this variance application will be removed from the Form 2A submitted with the RMPU Phase 1 OGDP, and the Form 2s and Form 2B submitted with the RMPU Phase 1 OGDP will remain as the full, complete project. We had numerous conversations with CPW and BLM during our application development, our submittal, and during discussions of the variance application. Again, CPW supports constructing the roads before December 1 so that Caris does not need to seek relief from the seasonal timing limitations. Another way that we plan to adhere to the intent of the Act and avoid adverse impacts is further expressed by the lack of residential building units nearby. There are no residential building units within 1 mile of the proposed location and access roads. The closest RBU is more than 2 miles and multiple ridge lines away from the entrance of the access roads, 12,700 feet to be exact. We have received no objections from any landowner or Rio Blanco County to construct the access roads prior to OGDP approval. The last element of the variance request is that the request contains reasonable BMPs or CUAs to avoid, minimize, or mitigate potential adverse impacts. The BMPs and COAs are listed here and can be further described in the exhibits N, O, P, and Q. Importantly, Caris fully agrees to reclaim the access roads with protective BMPs if the OGDP is denied. Caris also agrees to the condition of approval listed in the director recommendation to submit a Form 4 documenting the variance relief from within 30 days of an order to approve the variance. We have numerous subject matter experts available to speak to each of these exhibits in more detail if you have questions. In addition, the director supports these BMPs as listed. I will now turn it over to Ms. Wazelinski to conclude the presentation.
Thank you, Ms. Langley. We will conclude the presentation with a summary of the standard of review under Rule 502C. The variance application and testimony demonstrate that Caris meets its burden of proof for each of the 5 elements in Rule 502C. First, Caris made a good faith effort to comply with the applicable 300 series rules by filing the OGDP application ahead of its expected completeness date based on ECMC guidance, and by securing notice and petition waivers from the applicable interested parties. All interested parties have agreed that they do not object to the relief requested in the variance application. Second, the variance is necessary to avoid an undue hardship because if Caris is unable to construct the access roads before the OGDP is approved by the Commission, it will miss the federal unit obligation spud date or be forced to violate the CPW and BLM timing stipulations to protect HPH. If Caris is unable to meet a 2024 spud date, it will also lose its rig. Third and fourth, the variance does not violate the basic intent of the Act and will result in no net adverse impacts to public health, safety, welfare, the environment, or wildlife resources. Caris will adhere to the HPH timing stipulations and the plans, BMPs, and COAs incorporated in the variance application will avoid, minimize, or mitigate any potential adverse impacts. And fifth, the variance contains reasonable BMPs and COAs to avoid, minimize, or mitigate potential adverse impacts. Again, these are included in the variance application and in the director recommendation. So for these reasons, we respectfully request approval of the variance application. We thank you for your time, and this does conclude our presentation.
Great. Thank you, Ms. Wozlinski. We have in our packet a proposed order, and this question is not to prejudge where we're going with it. But I think the proposed order needs to have two clarifications if we were to run with it. One is that the granting of the variance does not vest in any way the granting of a subsequent OGDP or something along those lines. I assume your client would be comfortable with that.
Yes.
And then second, that the order should reflect that the roads are those roads that are depicted on your proposed exhibit. I think it's exhibit F, just so that we're crystal clear of what's being approved.
Yes, no objection.
Okay, so again, that's not prejudging anything. I just want to kind of lay the record in terms of what's before us. With that, I would turn to my fellow commissioners to see if anyone has questions with regard to the proposal. Commissioner Messner.
Thank you, Mr. Chair. Thank you for the presentation. I've got a few questions to clarify some things for myself. So there was a couple of construction timelines that were contemplated in your presentation. One was with an approval of the variance, and the other was without the approval of a variance. It seemed to indicate that, I mean, at least what I'm reading is that there's a timing stipulation for protection of wildlife for big game, and then there's another one for the golden eagle. In your presentation, it seemed to indicate that should the variance be approved, that the golden eagle timing stipulation would be fluid, depending on whether or not there was nesting occurring in the area at the time. And so therefore the timing of the construction of the well pads would be within that timing stipulation associated with the golden eagle. But in the scenario where the variance was not granted, it appears that that timing stipulation for the golden eagle is not fluid, but rather it is fixed. And so therefore your assumptions are for your construction timelines is that it could not start before September 1st. So to me, those two things seem contradictory to one another. So I wonder if someone could explain the rationale there.
Ms. Ryder.
Yes, thank you. Again, my name is Lindsay Ryder, and I'm the director of EH&S for Caris. So just to clarify, the access roads that we are proposing to build are within a half-mile buffer of the 3 golden eagle nests that we've observed. The well pads are outside of those buffers. So they would be constructed at a different time frame, potentially next summer, and they would be outside of those golden eagle buffers. We are here today because the access roads do intersect the half-mile buffer where they come off of County Road 5. And so to be prudent, we want to assume that one of those nests will be occupied, and we would not be able to construct until September 1st of next year.
Okay, but understanding that if you were to construct the pads, even if the access roads were created, there's significant truck traffic and activity that would occur on those access roads due to constructing the pads that could potentially impact the high priority habitat area for golden eagles, should you choose to build those pads within that timing stipulation. So it's not just the construction of the pads that's potentially problematic, but actually the traffic associated with construction further up along those roads. Is that correct?
Yeah, there is the potential. And if you do look back at the map, the two nests that sit on the other side of County Road 5, you'll see that the half-mile buffer just overlaps the entrance to the road. So I believe that the disturbance or impact would be minimal because of where those nests are located across the Peons Creek area and on the other side of County Road 5, which is utilized by lots of public traffic.
Okay, I didn't see that actually contemplated inside of the conversations that happened with CPW, and so this is why I'm asking now. Another question that I have is in regards to the application was submitted in April for the OGDP. Did that application go back to Karis to draft status? And if so, how many times did it go back to draft status prior to, at least what I understand now, is the formal timing where the completeness review is happening because the application is complete?
Good question, Commissioner Messner. That application only went back to Karis one time. On late August, we turned that around in 7 days. As you remember, that was over Labor Day weekend, so we turned it around. We have yet, since September 7th, to receive that completeness determination as of this morning.
Right, but the completeness determination, that timeline typically starts when an application is complete. So after the application has been remanded back to the applicant to make revisions in order to be able to start the timeline for a completeness review, it has to be a complete application. So I think what I'm hearing you say is that, in your opinion, the application was complete and the timeline started for a completeness review in August. Is that right?
I'm happy to weigh in here as well, Commissioner Messner. So Ms. Langley is correct that the first set of completeness review comments came on August 30th. But Karis was relying on the enhanced completeness review, which staff, and we realize we're all learning through this process. Staff's goal was to achieve completeness during that initial time period in 60 days. So and that's calculated from the time of filing. And that would assume that the application is submitted back for any corrections and a potential 1 to 2 week window to make those changes before completeness is ultimately determined. So that's how it was laid out in an operator meeting. And again, lessons learned all around here on this timing, but that was the reliance, is that entire process would take, a much shorter time than it has taken.
Okay. Those are the questions I have right now. Thank you.
Commissioner Ackerman.
Thank you, Mr. Chair. I appreciate that. I appreciate the presentation and the thorough communication. Just one question, and it's centered around potential compensatory mitigation in the wildlife plan. It appears that you've worked with CPW to work on a compensatory mitigation plan, or alternatively, potentially Karis initiated and completed wildlife mitigation plan. Can somebody talk about that just a little bit? Have you made any more progress on a proposed plan, or is the intent to pay compensatory mitigation?
I'll take that question. Thank you, Commissioner. We plan to pay the fee, and we've actually worked with CPW on this access route and the fee associated with the access roads. And we are willing to pay the fee just for the access roads, and then we will be whole when we pay the remaining amount after the full OGDP is heard and hopefully approved.
Thank you. Just to clarify, Ms. Ryder, thank you for that response. So this compensatory mitigation that's proposed in the wildlife plan is for the project as a whole, including the development of the pads and not just the roads.
That is correct. Yes.
Thank you. And my notes show that it's a payment of upwards of $211,000. Is that correct?
Yes, that is correct.
Okay. Thank you. No further questions, Mr. Chair.
Other questions from the commissioners? Commissioner McGowan.
Thank you, Mr. Chair, and thanks for the presentation and clarifying some questions that I had. I think I'm still a little, I'd like some more clarity about the timing and the requirements for the federal unit obligation. So if I'm understanding correctly, you still don't have an APD from the BLM, lots of acronyms, to drill yet, but they're saying yes to building the access roads before you get the APD, or do you have to wait until after you get the APD from them? Am I understanding? Sorry.
No problem, Commissioner McGowan. I'll take the first part of the federal APD and then I'll punt it to Aubrey to talk about the federal unit obligations. We anticipate receiving those federal APDs by September 30th, which is Saturday. In an email entitled in our exhibit, we do have validation from BLM that no major deficiencies were found with our APD submittal. They're on track. BLM obviously has authorized approval of construction of the roads once those APDs are actually approved in the corresponding environmental assessment, which may include additional conditions of approval, but we have yet to see those approvals, but are hopeful by Friday or Saturday.
And then you, can you remind me of the date that you have to have the first spud to meet your obligation?
Yep, Aubrey, do you want to talk about the federal unit obligation spud date?
Yeah, sure. Thank you, Aubrey Besant, again, VP of Land for Caris. So our extension date that was granted to us after the acquisition of XTO is October 26th, 2024. So we have to have a rig on location and be spudding on that date.
Okay, thank you. So you're trying to build the access roads before December 1st because of the wildlife time stipulations. So if the BLM runs behind and you don't get your APD, then what happens? If we say yes to the variance, but BLM is not timely with their APD, how does this affect your schedule and what would happen?
Yeah, Commissioner McGowan. Caris commits, obviously, we don't have authorization to begin construction of those roads until we do get the APDs in hand and approved. We have no indication as of checking as of last Friday and that there are any delays that exist. So we are hopeful that there could reasonably be at least a 6 to 8 week window for the construction prior to December 1st.
Okay, so thank you. And can you remind me in the order, is it clear that this commission would be providing a variance for the road to be built before December 1st? And if it happens after that and you're out of your timing, you'd either have to come back to this commission or you wouldn't be able to build the access roads.
Thank you, Commissioner McGowan. The proposed order doesn't, as far as I recall, have a date for construction. However, that HPH timing stipulation would kick in on December 1st. So if the variance is approved, you're approving construction of the access roads and maintenance of those roads prior to the OGDP hearing. And, within the application and even as a COA, which Caris commits to submitting via Form 4 on 2 temporary location IDs that staff has assigned to each location, that Caris will adhere to those timing stipulations. So via Form 4 COA BMP, they would be incorporated in the order, but I don't believe the order itself puts a time period on construction.
Okay, so I think what I hear you saying is the condition of approval is our assurance that it would have to get done before December 1st.
Correct, or Caris would be in violation of that timing stipulation.
Okay, thank you.
Commissioner Cross.
Thank you, Mr. Chair, and thank you for the presentation. I just want to touch on a couple clarifications with respect to the federal unit. In slide 18 on the presentation, it showed the unit boundary as well as the PA boundary. So to understand, there's already been a Yates well for the participating area that was highlighted in green. Is that correct?
Yes, thank you. That is correct. So there is a participating area. There is a Yates well that's producing and currently holding that acreage that's in the current participating area. So all that white on the map, inside of the boundary, but outside the PA is the acreage that's at risk.
Okay, and so everyone's clarification, so if you're not able to meet the obligation for drilling the new well after the extension, everything that's in white would be contracted and all you'd have in the unit is the participating area.
That's correct. It's approximately 8,200 leasehold acres that are at risk.
Okay, and then the one other question, building off of Commissioner McGowan's comments, talked about if the APD does not come in, if for some reason the APD did not come in on September 30th or started to push into the timing limitations, would Caris, given it's a BLM delay at that point in time, would Caris consider requesting the suspension of operations on that to bridge that gap, knowing that it's at that point in time a BLM issue and not an issue with anything on our end or on your end?
Yeah, I can answer that, and Kelsey may jump in as well. But yeah, we'd consider submitting a request for a suspension or an extension to try to get the BLM, try to get those BLM permits approved. We would go that route.
Okay. Thank you. That's all the questions I have for right now.
And
Commissioner Messner?
Excuse me. I was just going to add to that to state that Caris didn't file the variance until it had a reasonable amount of certainty from the BLM that those APDs would be approved. So that's what triggered that and the CPW consultation, and obviously Rio Blanco County ECMC staff to go ahead and file, because Caris has a reasonable certainty that those will be approved on time.
Commissioner Messner?
Thank you, Mr. Chair. Just one other question as I'm trying to better understand the timeline here. So correct me if I'm wrong, 2020 XTO asked for an extension from the BLM. That extension was to go to 2022. Caris purchased XTO in 2021, knowing that there was the 2022 deadline, and so asked for an extension at that point to 2024. And so Caris, as of 2021, understood that there was a deadline that was going to be associated with this particular area at 2024. Is that correct?
Yeah, thanks. That is correct. So when we were in the middle of the acquisition from the purchase signing of the purchase agreement to closing, which we closed in July of 2021, we were already getting ahead of the game and putting all of our requests together for an extension. And actually we amended the entire unit agreement. So it's more than just pushing out the spud date. We actually amended the agreement that conformed to our development plan and how we develop out here. So rather than 3 wells every year, we're able to get on a pad, occupy it for a year, drill several wells on there, and then have 18 months from the day we get out that we spud the last well on that pad till we spud the first well on a subsequent pad. And so it was a huge undertaking. We'd done it previously in our legacy asset that we acquired from Encana. So it was along the same lines. So we anticipated that and right away worked with the BLM to get that extension. And part of that was a timeline of when we thought we could, get these permits. And so the development team and several other Caris disciplines, worked with the BLM on timing, considering big game stips and other like the Eagle stipulations and construction windows on when we could obtain permits, get the construction done, and hit that spud deadline.
Okay. And I guess to help me better understand your argument, the application was submitted to ECMC, COGCC at the time in April of 2023. What precluded you from submitting that application sooner?
I can take some of this, and then if anybody else from my team wants to chime in. But to start, like I said, we closed in July of 2021. We were, filing paperwork with BLM, ECMC to get change of operators approved. And then we went through the process of getting this extension. We didn't want to go start filing permits and applications until we were certain we were going to get the extension approved from the BLM. And then there's lots, we understanding the asset is huge. Understanding the infrastructure that we just acquired, the topography, the planning process involves on-site selecting pad locations. I believe we started in September of 2022 on-siting with the agencies. And so there's just a lot of planning, and in this, this is a typical timeline for Caris when we're planning our development plan, is that there's a lot of pre-planning that goes into place. And from Alex could probably chime in here, but from inception idea to execution, when we submit, it's 12 to 18 months process, just putting all the pieces together with locations, infrastructure needed, et cetera.
Hi, this is Alex Yancey. I'm the asset manager. And just to build on what Aubrey was talking about, we did a multi-agency on-site reviews in September of 2022. And so there was a significant amount of effort that was put in prior to those on-sites with those agencies. And then following that, we made adjustments and to put our applications together, and then continue on, and then getting that ready for the April 2023 submittal with that. So we have been working this basically since time of close between the subsurface and surface teams and our operations and development to put comprehensive plans together.
Okay, thank you.
Further questions, Commissioner Cross?
Thank you, Mr. Chair. And I just want to build off of Commissioner Messner's comments and questions there a little bit. As you've been developing more comprehensive plans, do you have an idea or any kind of plans with BLM about where you would try and move next within the unit boundary to expand that participating area?
Yes, thank you. Excellent question. That when we did the on-sites mentioned in September 2022, we identified 2 additional pads that would also meet our drilling unit obligations, and the H28 and the K27 pads for a total of 49 other locations that would be served through these access roads.
And where in relation to the B27 here would those locations be?
To the south and to the east of these locations.
Okay.
Up Lee Gulch drainage.
Okay. And do you know if there are similar timing stipulations within those areas as well?
They would fall in the HBH timing windows as well. Yes.
Okay. And just to understand a little bit on the planning side, why, if there was several different locations chosen, was the B27 location chosen? Was it for ease? Was it easier to access? Just so we understand that a little more.
Yes, so it's closest to County Road 5, and so just for ease of infrastructure as far as we step into this new area and then test our production results and continue to evaluate the area, and then the others will continue to build on from there.
Okay, perfect. Thank you.
Additional questions? All right, I'm seeing no further questions. AG Davenport, if you could visualize yourself. Do you have some suggested language along the lines of what I led off with in terms of no vested rights and identifying the actual specific roads?
I do. If you give me a moment, I will share my screen so you can see what I've got. Okay. Can everyone see that? This is a, what I did is copy pasted from the recommended order the first 4 paragraphs of that, the order section of the recommended order, and made the changes in red line.
Okay, I can see that. Ms. Wazelinski, are those suggested changes, assuming we have a motion acceptable to your client?
Yes. Thank you.
Okay, great. Then I would move approval of the variance with the changes as reflected in red.
Sorry, Mr. Chair.
Go ahead.
I apologize for interrupting. I just thought of one more thing. In addition to the now paragraph 5, which provides that the Form 4s that are contemplated being submitted will also include that Exhibit F map. So there's a depiction of where the access roads are and where they go and that kind of thing. I see Ms. Wezelinski nodding in the affirmative. I think that means
you.
you're okay with that? Okay.
Yes.
Okay.
Does that work? I'll try to fix the formatting here, but that's
okay. We get the gist of it. Okay, so I again would move approval of the variance order with the exhibit changes in red as crafted by Assistant Attorney General Davenport. Do we have a second? Commissioner Ackerman?
Mr. Chair, I'll second and have a couple of comments when the time is appropriate.
All right, go ahead and comment.
Before, apologies, commissioners, should I stop screen sharing?
Yes, you can stop screen sharing. Thanks.
Thank you, Mr. Chair, and thank you to everybody for the work that's gone into this. It's been considerable, and I appreciate Karis making a broad panel of staff available for the discussion today. I wanted to note that federal leases are issued under a separate initial land use process that generally include discussions about wildlife concerns before a parcel is even made available for lease. And wanted to kind of mention a little bit the intent of Senate Bill 181 here. The intent is to protect public health, safety, welfare, the environment, and wildlife resources. And it has been noted in this hearing that wildlife is a primary consideration in these potential OGDPs, but also in the construction of the roads. And the inclusion of CPW determined HPH or high priority habitat in our regulations is specifically intended to highlight wildlife concerns and to initiate a conversation about how to best avoid, minimize, and mitigate these concerns. And I view this creative solution as a good faith effort on all parts, specifically Karis, CPW, BLM, and Rio Blanco County and the U.S. Fish and Wildlife Service to address and minimize impacts on wildlife within and around HPH. I appreciate the chair bringing up the issue of this variance, not presupposing any OGDP approval. And I agree with that. I think that this variance, should we issue it, does require that Karis also approach the yet to be approved associated OGDP or OGDPs in a manner that ensures they're of the highest quality in order to ensure that this initial good faith effort, should we approve it, isn't made defunct or further complicated by delay of OGDPs for any related deficiencies. I wanted to note the steps that have been taken here, including timing limitations, compensatory mitigation, Karis's commitment to BMPs, and also commitment to other wildlife-related communication with CPW, BLM, and the U.S. Fish and Wildlife Service. So I appreciate the extensive consultation by Karis on this issue. I think it was an appropriate approach to this somewhat unique challenge. And I do agree that Karis has met the standards for the issue of a variance and has complied with the specifics, but even more importantly, the spirit of our regulations surrounding HPH, noting that this is the approach that CPW has agreed is the least impactful approach to wildlife in these developments. I think, I would sum that up, Mr. Chair, by saying that I think this is an example of how the inclusion of HPH mapping in our regulations provides the most up-to-date wildlife issues that need to be addressed, and how these regulations work to initiate discussions that then generate paths and methods to protect wildlife that were often not fully addressed prior to Senate Bill 181 and prior to the inclusion of high priority habitat within our regulations. And again, appreciate the solution that's being worked towards here and am in support of the issuance of these variances.
Thank you, Commissioner Ackerman. Commissioner Messner?
Thank you, Mr. Chair. Thank you, Commissioner Ackerman for your thoughts. I will note, Mr. Chair, that typically we have a deliberation phase before we do motions, but we can certainly have it at this point as well. Because it's important for me on this one to hear from my other commissioners of their thoughts, because to be honest with you, I'm on the fence on this one. I'm not sure that this applicant has met the burden of the variance request, particularly around undue hardship, because I do believe that the undue hardship that was created here was created solely by Karis and not by other situations. And so as I look at the timing of this, I think that there was clearly time to be able to submit applications even concurrently with the BLM, understanding that there was going to be timing stipulations and wildlife considerations necessary in order to be able to complete this application. And so I struggle a little bit with having to reimagine the rules as they were contemplated during the mission change rulemaking on how we review OGDPs by bifurcating this into access road versus pad construction. I understand the challenges here, and I understand Commissioner Ackerman's considerations of wildlife, and I do actually think that the proposal does have the ability to be protective of wildlife, but my concern is one of A, precedent setting as far as variance being requested because applications weren't applied for in a timely manner, and B, that the full variance requirements associated with this may or may not have been met. And so I am curious to hear other commissioners' thoughts on this before I make my decision, but right now I'm not convinced that the undue hardship piece of the variance request is met.
Commissioner Kraus?
Thank you, Mr. Chair, and thank you for expressing your concerns, Commissioner Messner. I, for one, think that the undue hardship was absolutely met here. Having worked on federal unit work before, there's a lot of timing and work that goes into this. The fact that Karis was able to renegotiate the unit agreement, I think, is a major undertaking on its own. And the fact that, and I think to compare it for some of those listening in today, to compare it, we oftentimes hear people, whether it's in the DJ, whether it's in the peons, talk about trying to set up locations can easily take, as was mentioned today, 12 to 18 months. And then within that 12 to 18 months, you're also talking to local governments, you're also talking to staff, you're talking to CPW, or you're making those consultations. And additionally, on this side, you're also trying to work with BLM. So you have another stakeholder in the process. And so to me, the fact that between getting these assets from XTO in 2021, working to renegotiate the unit agreement, which is a major undertaking, especially considering that the model unit agreements often require wells to be drilled within 6 months after the participating area is granted, to adjust it so you have this 18-month period so you can meet these timing limitations is an important aspect with what Commissioner Ackerman said, trying to make sure that we're protecting wildlife, because I think key among protecting public health, welfare, safety, environment, and wildlife resources in this part of the state, the environment and the wildlife resources are the key here. And so I think negotiating the unit agreement to meet those timelines was obviously important. And then once the unit agreement was amended, taking the time to work on a development plan, knowing what's going to be the best area to expand that participating area, taking the time to plan that, understanding that all the while Karis is trying to make sure that they're meeting those timing limitations to avoid and minimize and mitigate impacts to the environment and wildlife resources, I think is very important. So to me, I think that the filing of the application, honestly, within a couple of years of getting the assets from XTO, I think was absolutely working as hard as they could, especially given some of the constraints in that area with the high priority habitat, and trying to make sure that they are being a prudent operator to meet those timing limitations. So I absolutely understand your concerns, Commissioner Messner. But in a lot of ways, I see the time between getting the assets, working on the unit agreement, trying to make sure that they are meeting the timing limitations, working on creating a development plan, what's going to be the best area to go to next. I absolutely think that Karis did everything that they could and are doing it in the correct way, as opposed to trying to rush anything or trying to just pay for additional compensatory mitigation and go into the timing, like breach the timing limitations and stipulations. A couple other comments. I think what really sticks out to me here is CPW's approval, staff's approval, BLM's approval of these processes. But I think more than anything else too, just understanding the difficult and unique nature of federal units, the idea that, as they said, potentially 8,200 acres could be potentially lost by this, I think is very drastic. And that's not to put the economic benefits of a company above it, above the potential considerations, but the fact that they are trying to keep these 8,200 acres within the proposed unit, all the meanwhile trying to make sure that they do meet those timing stipulations, I think is very important as well. So especially given the approval from CPW and staff and BLM, I am absolutely in favor of this.
Commissioner McGowan?
Thank you, Mr. Chair, and thank you to all my fellow commissioners for their input. I have to say, when I first read the variance request, my first thought was, poor planning on your part does not meet an emergency on ours. But I feel better knowing that they've had already asked for an extension with the BLM, that the BLM is close to approving an APD, and they initially have told this operator they don't see problems with this, and the understanding that this is not guaranteed that we're going to approve an OGDP by the time it gets to us. So the risk here is on the operator. I'm also appreciative of the conversations ahead of time with our staff, BLM and CPW, and them all agreeing that this is probably the best path forward. That being said, I certainly would not want to see this be a regular request from operators. Folks know how long it takes to get through our process, regardless of, us saying we're trying to do it this way and we're trying to meet this timing. I think it's been pretty clear how long it takes to get to completion and then what happens after you hit a completeness date. So that being said, I'm supportive. I think that the operator has made good faith effort and has shown that they meet the variance request requirements, but would not want to see this become practice with operators.
Agree. Further discussion, deliberation. Sorry if I jumped the gun, Commissioner Messner, with a motion before we thoroughly deliberated. Commissioner Messner?
Thank you, Mr. Chair. And thank you for the input, my fellow commissioners. That's important for me to understand your perspectives on this. I still have heartburn with this, but I'm willing to be flexible in this particular situation because of the complexities with this particular situation. The fact that Karis doesn't have as much experience with OGDP applications as some of the other operators we see before us, and the complexities with the federal units and the asset acquisition. I think Commissioner Cross's explanation there was helpful in my determination, but I also agree with Commissioner McGowan that, at least from my standpoint, this is a one-time situation, and that I'm really uncomfortable with this. It is inappropriate to be reviewing OGDP applications outside of the rules and without the holistic application being considered. And I do think that the risk on this situation is on the applicant. And so I liken this to approving a driveway permit.
Commissioner Messner, you became mute. Not you, but your computer. You are still muted.
Hello?
Yeah, now we got you.
Okay. Anyway,
You were,
I was saying that I liken this to a driveway permit being approved prior to a building permit in a housing situation. And I have seen plenty of situations where the house didn't get approved and the driveway had to get reclaimed. And so, so with that, I will be in support of this, but with heartburn.
Commissioner Ackerman?
Thank you, Mr. Chair. And can I ask one question? And this might be perhaps on staff or the AG's office, but are there stipulations in the regulations presuming, let's make the argument that these OGDPs are eventually not either pursued or not approved? Would that trigger automatic reclamation of these roads, or would we need to take action here today that would direct reclamation of the roads should the project not go forward?
Ms. Wazelinski?
Thank you, Commissioner Ackerman. I'm happy to answer that question. An exhibit and one of the COAs that Karis agrees to is to fully reclaim the access roads if the OGDP is denied. So that is a condition of approval. It's an exhibit to the variance application, and it would be incorporated in the Form 4 that Karis files on the 2 temporary location IDs.
Thank you, Ms. Wazelinski. That's helpful. And with the nuance of, let's say they're not denied, but rather Karis chooses not to go forward, would that also be covered?
I believe so, yes. If there's no OGDP at the end of the day, the access roads are going to be reclaimed.
Thank you for addressing that.
Further discussion or deliberation? All right, with all of the commissioner caveats and nuances as articulated during deliberations, I would look for a vote. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. All right, thank you for the presentation. Thanks to staff for their analysis as well as to our federal and state partners. With that, it's 10:30. Let's take a morning break and return at 10:40. Okay, welcome back. This is the Colorado Energy and Carbon Management Commission. It is Wednesday, September 27th, 2023. It is 10:40, and we will continue with the agenda that was created for us. We next will take up docket 2212000361, an oil and gas development plan. The applicant is Crestone Peak Resources Operating LLC, operator number 10633. Ms. Jost.
Good morning, Chair. I'm going to share my screen and we'll go ahead and dive in. It looks like we have all of our panelists. Thank you very much, Hearings Manager Larson.
Why don't we go ahead and take care of the swearing ins?
Okay, great. Dan, Jeff, Scott, and Kathy, can you all turn on your videos so we can get sworn in?
Good morning, everyone. I believe you're all familiar with the drill, but for all of Crestone's witnesses, I'll go one by one and ask you to raise your right hand, state your name, and that you swear to tell the truth. I'll start with Mr. Harrington.
Dan Harrington, Crestone Peak Resources. I swear to tell the truth.
Thank you. Mr. Annable?
Jeff Annable, Crestone Peak Resources. I swear to tell the truth.
Thank you. Mr. Farkas? Oh, you're on mute.
Scott Farkas, Crestone Peak Resources. I swear to tell the truth.
Thank you. Ms. Stearman?
Stone Peak. I swear to tell the truth.
Thank you.
All right, the floor is yours, Ms. Jost.
Great, thank you, Chair. Okay, can everyone see the slideshow? Great, thank you very much. Well, good morning, commissioners, staff, members of the public. My name is Jamie Jost, and I, along with my partner, Kelsey Wazelinski, represent Crestone Peak Resources Operating LLC in the Chico-Watkins South and Watkins 30-5-5H OGDP application before you today in docket 2212000361. Crestone would like to thank the City of Aurora for its participation through the local permitting process and its approval of the 2 locations subject to this OGDP And we'd also like to thank the ECMC staff and the director for their efforts on this OGDP, as well as the box elder cap under which this OGDP was filed. This Chico Watkins OGDP was the first OGDP filed under the box elder cap, and the application was filed in December of 2022. As a refresher, the box elder cap was approved by this commission in order number 535-1396 on November 2nd, 2022. Order 535-1396 established an approximate 37,520 acre cap in the application lands in the cap, which include the application lands for the Chico Watkins OGDP up in front of you today, for the development of gas, oil, and associated hydrocarbons from the Niobrara, Codell, Greenhorn, and J-Sand formations. Under the approved cap order in Rule 314B5, the commission granted preliminary siting approval for the two locations in this OGDP. The first being the Chico Watkins South Pad, and the second being the Watkins 30-5-5H pad. These two locations are in the southernmost area of the box elder cap and are within the city of Aurora. Pursuant to Rule 314E11, Crestone submitted a detailed ALA as part of its preliminary siting request for these two locations in the box elder cap filing. The commission rules and the statement of basis and purpose for Rule 314 provide that if an operator receives preliminary siting approval through a cap, then the operator need not submit a duplicative alternative locations analysis for a future Form 2A within the cap, which is why you do not see an ALA in this presentation. But even if it was required, there's no Rule 304 ALA criteria that apply to either the Chico Watkins South Pad or the Watkins 30-5-5H pad. In terms of the OGDP submittal, Crestone complied with all notice requirements of the OGDP. No formal petitions were filed, and no formal comments, public comments, were submitted on the Form 2As. Crestone does appreciate the questions we received from the commissioners before this hearing, and we will address those questions in the presentation today. So with that, I'd like to go ahead and turn it over to Mr. Dan Harrington from Crestone for the remainder of the presentation.
Thank you, Ms. Jost, and good morning, commissioners, staff, and members of the public. We appreciate the chance to appear before you here today. I'm here to introduce the Chico Watkins OGDP. This OGDP is intended to encompass two pads. One, the Chico Watkins South, will be a new pad. And the second, the Watkins 30-5-5 or Watkins North, will be an expansion of an existing location. These two pads will drill 2-mile laterals east and west and will develop approximately 4 sections of minerals. Both sites are within the city of Aurora. They are captured in both the Aurora Operator Agreement and the box elder cap. There are no RBUs within 2,000 feet of either pad surface, no schools, HOBUs, or DOAA, and no high priority habitat. There is DI community, but no RBUs, again, within 2,000 feet of the working pad surface. And as Jamie as Ms. Jost went over, no ALA was required, and we also had no public comments on this OGDP. CPW and CDPHE elected not to consult on this location. Next slide, please. Thank you. The two pads will develop 2 DSUs, each approximately 1,280 acres east and west. We're looking at 11 new wells, which in addition to the existing wells in the DSUs will complete development. All new wells will be Niobrara wells. We are seeking 330-foot DSU setbacks, and those setbacks are supported by our engineering testimony. Next slide, please. Quick breakdown of the wells that currently exist in the OGDP area. We have 4 existing wells in sections 25-26, the western DSU. Those wells are and will continue to produce. We have 4 1-mile wells from the existing Watkins 35-5H phase 1 site. Those wells will continue to produce. And we have 1 additional 1-mile well, the Tebow 29-2H in section 29, which is and will continue to produce. We have gotten ahead of our P&A and reentry requirements for this OGDP. The TBO 29-1H, 1 mile lateral to the south, was P&A'd in August, and 2 legacy non-Civitas vertical wells in Northwest Section 29 were re-entered and replugged also in 2023. Our intended operational timeline is pad construction in the fourth quarter 2023. We'll probably start with the Watkins North and then go to the Chico Watkins South. Drilling will proceed from December 2023 through January 2024. Completions is planned for the second and into the third quarter of 2024 and will be online in the third quarter. Again, these sites trigger no ALA criteria. They were both approved with preliminary siting analysis in the box elder cap. And again, we have no RBUs within 2,000 foot within a DI community. And you can see the criteria that do not apply in Exhibit 7 here. Again, these pads are in the city of Aurora. They are aligned with the original Aurora operator agreement siting that was the backbone of the box elder cap. The local permits for these sites were submitted in February 2023, and both were approved in July 2023. We did conduct a neighborhood meeting pursuant to Aurora regulations on May 1st, 2023. There was 1 attendee and no comments were registered. And as you can see here, the closest RBU is nearly 4,000 feet away. I'll run through some of the best management practices we're planning for this site. We're committing to use Group 3 drilling fluids to minimize odors. Drill cuttings will be stored in closed containers and trucked off site. Oil pipeline will be in place prior to the production phase of the new well, so oil will not be transported by truck from this site. Gas will obviously go into the existing flow line. We're also looking to install a consolidated facility model. There is an existing facility on the Watkins North Phase 1 pad that's relatively old. That facility will be scraped, and the existing Watkins North wells and the 2 new Watkins North wells will all tie back to the nearby Chico Watkins South facility. This will represent a net tank reduction from 12 to 8. While we're here, I'll address 2 questions we got in preparation for this hearing around what type of drilling rig will be used. Here we will be using a rig powered by dual fuel type 2 generators. Civitas did engage Excel Energy early and often on this site and offered to pay for upgrades to allow for an electrified drilling rig. However, after study, we were informed that due to capacity at and distance from the local substation, Excel cannot provide sufficient voltage to run the drilling rig here. We are investing in the electrical system to provide sufficient electricity to power the facility. So the facility will be fully electrified. Some additional air and odor practices. As I said, oil will be transported via pipeline. Maintenance emissions will be controlled. Tanks will have blowers in addition to ECDs. We will utilize the type 3 drilling fluids, and we will perform air monitoring for the life of the well. And that plan will be submitted shortly. And lastly, we will have an electrified production facility. We did receive a director's recommendation earlier this month for approval of both the Watkins South and Watkins North pads. I'll leave that at that. And lastly, we would ask the commission to consider approving this approximately 4-section OGDP for 11 new oil and gas wells from 2 sites, and find that the OGDP will protect and minimize adverse impacts to public health, safety, welfare, the environment, wildlife resources, and protect against environmental impacts on any air, water, soil, or biological resource in compliance with state law. And that concludes our presentation. We have subject matter experts on the line to answer any additional questions, and we look forward to the discussion.
Very good. Thank you for the presentation. Ms. Jost, did you need to wrap up?
No, Chair, I was just saying thank you to Mr. Harrington for the presentation.
Like minds think alike. All right. Commissioners, does anyone have questions? Commissioner McGowan.
Thank you, Mr. Chair. And my question might be for Ms. Stearman. I'm her favorite commissioner. Hi, Ms. Stearman. So related to the drilling rig, and in this case, we're doing dual fuel. And a while back, you were in front of us and proposed dual fuel with a battery assist, I think. Will there be battery assist for this one as well? And if not, could you kind of explain emissions benefits or no less benefits and or why you don't have the battery assist available? Could you talk about that a little bit in your decision making?
Yes, I can. I anticipated this question yesterday and kind of looked up some of our historic emissions profiles in kind of past conversations. This drilling rig does not have the battery backup, but it does have the dual fuel capability. We would expect the NOx reductions from the dual fuel setup to be about 15% reduced from a normal tier 2 diesel drilling rig. So there are definitely emission savings in the profiles we've run.
And is the battery assist just not available for this? Your timing and the location, etc.
I think that's accurate. Dan, I don't know if you had anything to add on that availability.
I can go ahead and answer your question, Commissioner McGowan. As of right now, we only have access to one setup, and it's going to be going to our Coolstra pad that we agreed to prior. It's going to be developed around the same time, so our other rig's going to have that, and we don't have access to that additional setup, another setup of that kind.
Okay, thank you. And then I assume that you all explored tier 4 and it's not available.
Yes, we're actually in the process of upgrading one of our rigs to tier 4. We've gotten a timeline from 6 to 12 months from when that's available, but we have ordered it. We're in the process of upgrading.
Thank you. I'm wondering if you all would be willing to go back to a map of where the locations will be and what exists and walk through again. Maybe Mr. Harrington, I'm very appreciative of you trying to centralize some of your facilities and minimize tanks. And I could, just from a visual perspective, could you explain to me what is moving where and what we changed so that we're lowering total number of tanks for this? And I'm going to assume then we're also lowering truck traffic.
Yes, and a slide 7 may be the best for this, if you don't mind switching to that, Ms. Jost. Thank you. And appreciate that question, Commissioner McGowan. As you can see, the 4 existing Watkins wells are drilled off the northern pad here, this northern blob here. There's currently, it's a legacy facility. It's, I would say not built to modern standards. There are 12 tanks there. When we initially looked at this OGDP, we realized that the best route would be to get rid of that old facility and start fresh with a new one. So that facility, which is approximately under the greenish dot southeast of the wellheads, will be removed. We're going to add 2 new wells to the 4 well array here at Watkins North, but all will tie back via flow line underneath the gap between the 2 pads to a facility that would sit here in the southern green box.
So 12 pads that exist on the legacy site are 12 tanks, sorry, will be removed. And then we're consolidating then tanks on the bottom of the lower green pad.
Mm-hmm.
And how many tanks will be there?
That will be 8 tanks. 2 are water tanks, 6 are oil tanks. Again, we'll flow to oil day 1, and those oil tanks are essentially a buffer for the pipeline system.
Okay, so the 2 sites are sharing the new tanks.
Correct.
Okay, thank you.
Sure.
Looking around for other questions, Commissioner Messner.
Thank you, Mr. Chair. Just a few questions here. I think you had indicated, and I think it was on the slide we just looked at, although you don't need to bring it up, that section 30 wells were going to be shut in, but not P&A. And I was just wondering if you could talk a little bit about why shut in and what the plans for those are.
Absolutely. Thank you for that question, Commissioner Messner. Those 4 wells still have production potential. They're old, but they're not ready to be P&A'd. They're being shut in primarily so we can do this facility consolidation. So they obviously need to be shut in while we're building the new facility and tying them back to that. As their life proceeds forward, when they reach the end of their useful life, like any horizontal, they will be P&A'd.
So you intend to tie those wells into this facility as well?
That's correct.
Okay. Second question, and I want to preface this with the fact that I was not present during the box elder cap approval, and so have gone back and reviewed everything. But one of the reasons for the development of a cap and the associated benefits of it, including preliminary siting, is that it is a comprehensive planning mechanism where we look at how do we collectively develop the infrastructure necessary to minimize impacts to air quality, moving around produced water, electrification, and these type of things. And understanding that this particular OGDP that's being proposed here really doesn't contemplate some of the stuff that typically you would see in landscape level plannings involved with a cap, particularly with produced water takeaway and electrification. How does this tie into the overall concept of the cap that was proposed and the infrastructure that is contemplated that would create the benefit of the cap?
Thank you for that question. I can offer a few ideas here, but I'll let other people jump in as necessary. One key one is the oil pipeline takeaway system that is being installed for day one production at all oil sites. On the electrification, again, it was our intention to electrify this site to whatever degree Excel could. We did consult with them during the OGDP planning phase, and the upgrades necessary to get sufficient voltage here, we were told by Excel, are simply not possible at any dollar amount they can do. But we did invest to allow for electrified facility. In the box elder cap, I'll have to look up the specific language, but we did commit to electrified facilities and to trying our hardest to get to an electrified drilling rig, but we didn't commit to an electrified drilling rig for every site. I can throw in some offset examples. If you'll recall, the Lone Tree OGDP and the Sky Ranch OGDP, which are a few miles northeast of here, but feed to a different substation. We did install the upgrades necessary for electric drilling, and both of those sites were drilled with electric rig. So we're really in the hands of the utility here.
Do you anticipate that the electrification infrastructure would become available for other OGDPs that'll be contemplated inside the box elder cap?
The way Excel's application process works is you can do high-level scoping early on, and we have with some of our other caps, but the actual application is typically site by site. We apply to we apply for an electrical study, an engineering review for every single site, and we can't always predict what Excel will come back with.
But as part of the application process for the cap, there was some consideration for these conversations to be looked at comprehensively as far as, how electrification could occur throughout the cap. And so I guess I'm curious, I'm hearing you say that it's not possible for this particular site, but is that still being contemplated throughout the cap?
It is. For every single site, we seek electrification at sufficient voltage to run a drilling rig.
Okay. And then I wonder if you could talk a little bit about produced water infrastructure and how that was contemplated in the cap and how that didn't tie into this.
Produced water infrastructure was not extensively considered or was not part of the cap approval. And the main reason is there are no commercial water injection facilities anywhere close by. The nearest one is in Weld County, tens of miles north. So constructing a produced water trunk line that far north was deemed to be both costly and potentially more impactful than the water hauling traffic. And as you know, the Niobrara Formation, after initial flowback, produces water at a relatively low rate and therefore necessitates relatively low amounts of truck traffic.
Okay. My next question is actually for Ms. Sorensen, as I'm curious regarding a CDPHE consult associated with this, and I guess want to better understand why it was why CDPHE chose not to consult on this one, and I guess wanted to just get CDPHE's thoughts on what's being proposed here, particularly around the drill rig that's being chosen.
Don't believe we have Ms. Sorensen with us at this point, Commissioner Messner.
Oh, she's not in the meeting.
I don't see her. I just looked in the panel and in the attendee list.
Okay. Well, I'll hold that. I mean, I am.
I do see her on the attendee list. I think I don't see her in the panelist list. No.
Then Ms. Amaro, let's see if we can raise her to the panel. There we go.
Hello. Can you repeat the question, please, Commissioner Messner?
Sure. My question was just the determination by CDPHE to not consult in this particular situation. And then, generally speaking, kind of the thoughts from CDPHE on what's being contemplated here as far as drill equipment that's being chosen by the operator to utilize, and how that ties into considerations inside the non-attainment area.
Certainly. Thank you, Commissioner. CDPHE was asked if we wanted to explore the option of a consultation for this OGDP. Now, for some history, we actually consulted on the box elder cap. The letter we sent to the ECMC was August 2nd of 2022. In that letter, we did note that Crestone had agreed to BMPs around multiple items. They did not agree to electrification of the rig. They did agree to essentially try and evaluate the availability of that. They did commit to using low emission completions equipment. So tier 4 engines or equivalent for their completions equipment. When we received the request, the option for the OGDP consultation, we took a look at where this exact OGDP was, the history with the cap. We noted that there are no RBUs within the radius for this particular OGDP. It actually does not lie within a disproportionately impacted community boundary. It is basically across the street from that. The boundaries actually reach to Watkins Road to the west. And the EnviroScreen did not raise any significant concerns with an overall total of, I want to say, 42 on this particular OGDP. So the only factor we saw specific to this OGDP was that it is a non-attainment area, which is not a default trigger for CDPHE. Looking at the neighboring surrounds and how far from the public they were with these locations, we decided we did not need a consult and that the prior agreed upon items in the cap were sufficient on that. The consideration of the drilling equipment was not taken into consideration on that, other than that they had tried to electrify. From CDPHE's perspective for air emissions, I would say that dual fuel is better than a normal tier 2. Is certainly a step up from there in terms of air emissions. Something like a natural gas with battery assist or a tier 4 engine is better, for sure. Electrifying being the preferred low emissions method, obviously, but it is not a requirement.
Thank you for that, Ms. Sorensen. That was helpful. And just to confirm to the applicant, it is contemplated that tier 4 diesel engines are to be utilized in completion activities. Is that correct? Because I didn't see that as part of your BMPs in the presentation.
That is correct.
Okay. Mr. Chair, I don't have any further questions.
Thank you, Commissioner Messner. Other questions from commissioners? Ms. Jost or Mr. Harrington, you made reference to the operator agreement with the city of Aurora. Can you just talk a little bit about that? And the city obviously didn't have someone to testify today, but I would like to highlight that point.
Absolutely. The City of Aurora Crestone Operator Agreement nominates specific sites and specific well counts at sites throughout Aurora that we're allowed to develop. During Box Elder, we discussed how the design of the cap followed that Aurora Operator Agreement, and Mr. Jeffrey Moore appeared in the cap hearing and reaffirmed that our cap was aligned with the Aurora Operator Agreement. So that follows through to the individual site plans. You'll see here that if you were to look in the Aurora Operator Agreement, both the Watkins 35-5H Phase 2 and the Chico Watkins South are nominated Aurora Operator Agreement sites.
Thank you for that clarification. Further questions for the panel? All right, seeing no further questions, we will turn to the deliberation phase of our consideration of this request. I'll start if anyone else wants to start. I mean, I think that this is consistent with the Box Elder cap. I think that the operator has done what they said they were going to do relative to the electrification component, and take them at the word that electricity is not available at these locations. I inquired about the operator agreement because I think that this is an instance in which the relevant local government preferred a comprehensive approach and led the way with the operator agreement. And I think that is an important consideration for this. Appreciate some of the other components to this Group 3 mud, the oil pipeline, the gas and flow lines, etc. So I am comfortable that these locations are approvable. Commissioner Messner, you had raised your hand right before I started rambling.
No, that's okay. Better to have someone start that was involved with the decision in the Box Elder cap, as I indicated I was not. And I agree, I think based on the testimony that was provided, and in particular, the testimony that was provided by CDPHE and the local government disposition, that as per the rules of the cap in this particular OGDP, that this is an improvable OGDP. I will note that as I think I indicated in my questions, that at least from this commissioner's perspective, the infrastructure development that is contemplated in comprehensive planning, like the cap, is one of the reasons as we developed the cap that was, at least from my standpoint, compelling in allowing some of the allowances like preliminary siting in OGDPs, and I understand that the city of Aurora was significantly involved in the development of this particular cap and had a lot of influence over ultimately how some of the infrastructure or some of the sites were determined in this particular situation. But I would love to see that level of comprehensive infrastructure planning and development occur if we start to see more OGDPs associated with this, and clear understandings as to why or why not some of these things can occur, because that's to me, from a preliminary siting standpoint, a really important element as to why we approve caps or don't approve caps. So, but like I said, with that, I'm not seeing anything in this that would not meet the rules, and so find it approvable.
Commissioner McGowan.
Thank you, Mr. Chair. I agree that this is an approvable application, and I'm appreciative of, I think, what I see as some continued looking for improvements and ways to minimize the impact and emissions. And despite the fact that electrification is not available for drilling, we're using Tier 4 for completions. we're at least not using straight tier 4 diesel for drilling. We've got dual fuel. I would have loved to have seen the battery assisted with that, but I get that it's not available. And I'm appreciative that they've thought about the layout of those two pads that are so close together and utilizing the same equipment for both so that we can minimize the number of tanks that are being used and the potential for spills and to reduce truck trips. So I'm appreciative of the operators looking at those, all the pieces.
Commissioner Cross?
I'll just be short. I also agree with my fellow commissioners. The one thing I'll just add is I'll be interested to see more about the switch to the tier 4 drilling engine as that's being rehauled and completed. So I'll be interested in seeing the updates on that.
Does any commissioner desire to make a motion?
Move to approve the OGDP.
Second.
Motion and a second to approve the OGDP. Is there further discussion? Seeing no further discussion, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. The OGDP is approved. Thank you, Ms. Jost. Again, always thank you to the ECMC team. There's a lot of background work here that doesn't come out necessarily in a pretty straightforward hearing, but we do acknowledge that great background work to Sabrina Trask and her team, as well as to others. So thank you very much. It is 11:16. We've got, I think, 2 more OGUPs. Why don't we take 5 minutes, and during that 5 minutes, let's get the next panel set up and return at 11:21. Oh, hey, Ms. Wozlinski. Yep.
Thank you. Thank you, Chair Robbins. I'm on the next matter, and the City of North Glen representative is supposed to give some comments at the outset of the Lizzie OGDP. They actually won't be available until close to noon. Unless actually I'm getting kind of some late breaking news here that they may be ready to join in a few minutes. So we may need to be a little flexible just based on when North Glen can come on here. He is available. Okay, we can take a short break and we can proceed.
All right, is 5 minutes good?
5 minutes should be fine. Yes.
All right, let's return at 11:22. All right, we now will take up the next OGDP. I believe that this is 2212-00350, an OGDP involving Kara McGee, the Lizzie OGDP. And Ms. Amaro, you'd indicated offline to me that our OGLA, Melissa Housey, had a short matter to make a statement about the record. I think if we could raise her first, that would be great. And then we would go to someone from North Glen would be next.
Melissa has been elevated, Mr. Chair.
All right. Good morning, Ms. Housey. If you want to visualize yourself or not, your call. There we go. Hi.
Good morning. Greetings, everyone, and thank you for this time. I'd like to provide a few corrections to the Kara McGee Lizzie OGDP's director recommendation. In the local government permitting and pre-application consultations section of the director's recommendation, it is stated that the city council hearing to determine disposition was scheduled for August 18th, 2023. However, the correct date the hearing was scheduled for was August 28th, 2023. The hearing was held on August 28th, 2023 and continued until September 25th, 2023 to provide additional information as requested by the City Council. The applicant may wish to expand on this request and what information was asked for and provided. The oil and gas permit was approved on September 25th, 2023 by the local City Council. Thank you for your time.
Great. Thank you very much. And now I think we're going to hear from someone from the City of North Glen.
Good morning, everybody. Brooks Kubota, Director of Planning and Development. Not familiar with your processes here, but I'm happy to answer any questions. As was just stated, the application was approved by City Council of a vote of 5-2. Really not really sure what interests or needs of information you have for me, but I'm happy to answer any questions you may have.
Yeah, if the relevant local government desires to provide any additional perspective around the approval, that's always helpful for us. It's not mandatory, Mr. Sabota. If there's it sounds like it was approved and you're comfortable with the location and moving forward with that from the city's perspective. Is that accurate?
It is, and I'll elaborate just a little bit on the disposition of the case in general. We had multiple hours of testimony in the first public hearing in which City Council asked for 3 additional items of information from a compliance and land use entitlement aspect. None of the information that was requested was relevant to the merit of the criteria of approval for the city's approval entitlement process. It was more related to ongoing information about severance tax, long-term monitoring of post and capping of the wells, and monitoring impacts that is typically managed and overseen by this board. With that being said, one of the no votes, I believe, incorrectly heard information that was provided in the public testimony by the applicant, in which the basis of their decision would seem to be in conflict with the information provided. The other no vote, I believe, was also a no vote based on potentially philosophical and not necessarily based on the merit of the application itself. The applicant has worked with the city staff and our consultant CGRS in their review of our requirements, which by all standards, I think is probably one of the more robust and comprehensive application document or processes that are out there at the municipal level. And so we worked with them for over about 1.5 years to get them to a point where they had sufficiently satisfied our requirements for purposes of bringing forward through the public hearing process. This was also approved by our planning commission and then went to city council. So with that, I'll be happy to answer any follow-up questions to that.
So it did go to planning commission and that was approved as well?
Yeah.
Okay, great. Does anybody have questions for Mr. Sabota? Commissioner Messner?
Thank you, Mr. Chair. And thank you, Mr. Sabota, for being here. Always great to have the local government's perspective on these. And actually just want to ask you a couple of questions about your process, because this is the first time we've had you in front of us, and always appreciate local governments that choose to have a land use process for oil and gas development. And so I wonder if you could just elaborate a little more on your review process, how, what types of land use codes are applicable to the oil and gas, and like when you developed oil and gas regulations within North Glen. Not necessarily relevant specifically to this application, but since we've got you, I'd love to hear about it.
Great, no problem. So I will be the first to admit I'm filling in for our senior planner, Eric Enzi, who's our project lead. So I know enough to be dangerous about our policy regulations. I will say that this is probably the first and last time you will see a city of North Glen land use application come before you, primarily because of the policy regulations are such that there's literally nowhere else within the city limits that you could petition for an application in North Glen. So I think the other aspect to it is, as far as where the existing mineral resources are within the surrounding area, this is likely the only manageable location that is within city of North Glen boundaries that has the potential for mineral resource extraction in general. So you're looking at me for the first time and probably the last time on that front. That being said, I will say that it was about 2.5 years ago. It may have been in response to Senate Bill 181 that we retained a subject matter expert to update our regulations. Prior to that, we had had one oil and gas permit back in 2012, essentially in the almost identical location that we are talking about today and considering under this case. And with that, we did a very, very comprehensive, and I would say beyond my skill set of policy recommendations to ensure environmental, social, and compliance with that. Our criteria is not unlike most land use criteria. Is it compatible with the surrounding uses? Proximity and impacts, noise mitigation, traffic mitigation, the typical things that you see for normal land use entitlement, just applied in a more specific manner as it relates to this. The one thing I will say where perhaps we are more robust than others in the surrounding area is our best management practices addendum. It is extremely extensive. And to that end, I believe with monitoring, and you'll have to forgive me, and maybe Tracy or someone from Oxy can elaborate further on that. We have additional reporting requirements that go above and beyond what the state has identified in terms of that. But primarily, that would sort of be the overview. And I will say that in working with Oxy, they have been very, very reasonable and very willing to work with us in terms of understanding and interpreting this. As I said, we brought in CGRS, Dresden Kennard, to help us navigate this process, because neither myself or Eric have the ability to truly understand the technical merits of what's otherwise identified in our BMPs. And I think that overall, this has been a very, very productive and collaborative process working with them to get things to where they need to be. And it has taken them quite a while because I think of the extensive nature of our requirements. And if it would please the board, I'd be happy to forward our policy stuff to whomever would be appropriate, and you guys can take a look at it and sort of see what we put together.
No, that's great. I really appreciate that information and you being with us here today. And I am a land use geek, and so would love to see your regulations. And so, you know, if whenever you have an opportunity, feel free to shoot them my way at least.
All right.
And but thanks for being here today, and thanks for that explanation. That was super helpful.
Certainly happy to have.
Great. Any other questions? All right, seeing none, we will turn to the applicant for its presentation.
Thank you, Chair. I believe we are just missing two panelists. Before we get sworn in, it's Garrett Llewellyn and Nick Lowndegan. And Nick is on. So Garrett Llewellyn would be the last panelist. And if everyone could please turn their cameras on.
Mr. Chair, this is Angelica. We do have the public commenter on standby.
Oh, my bad. Yes. Let's Ms. Weslinky, if you want to just hold your folks for now, and let's have the public comment provide their comment.
Sure. Yep, we can. Oxy team can go off camera, please. Thanks.
We're getting good at this visualizing and unvisualizing here. Ms. Weisner?
Good morning. Hello, commissioners, and thank you for your time this morning. My name is Dr. Megan Weisner, and I'm the Senior Environmental Epidemiologist for the City and County of Broomfield. As an adjacent local government, Broomfield is concerned about the potential adverse impacts to the health of our residents from exposure to individual pollutants such as benzene, and the potential for increases in ozone and particulate matter from the Lizzie B pad. Current ECMC rules do not require that operators analyze the potential for emissions to contribute to regional ground-based ozone, particulate matter, or require that operators meaningfully analyze the potential for emissions to impact public health. A recent study from Boston University adds to the large body of peer-reviewed literature linking emissions from oil and gas facilities to unhealthy air and adverse public health impacts. The study found air pollution in 2016 from the U.S. oil and gas sector resulted in over 400,000 asthma exacerbations, 7,500 excess deaths, and $77 billion in total health impacts. Attributable mortality cases were largely centered around oil and gas producing areas in the U.S., including Weld and Adams County. The Lizzie B facility will emit hazardous air pollutants such as benzene and other BTEX compounds. These pollutants are of particular concern to Broomfield's residents because our air quality monitoring system has captured elevated levels of HAPs that occurred alongside an increase in the reporting of upper respiratory and acute symptoms for adults living within 1 mile of oil and gas facilities that were designed to have the most extensive best management practices. Adverse public health impacts from emissions released by oil and gas occur at levels far below established health guideline values. That's because health guideline values are not set at levels that correspond with nosebleeds, respiratory symptoms, headaches, and other impacts commonly reported by individuals living near these facilities. The health guideline value for benzene is based on a 1984 study that looked only at changes in red blood cells in mice. In addition, relying solely on health guideline values is not an adequate way to protect public health because they do not consider at what levels health impacts occur from exposure to multiple contaminants. Your rules do not require that operators analyze the impact of ozone precursor emissions on regional ozone or particulate matter. These are significant gaps in your permitting rules, and without this analysis, you cannot determine if construction and operation of a new oil and gas facility can be done in a manner that is protective of public health or the environment. Broomfield, along with other local governments, submitted comments to the ECMC on February 24th, suggesting updates to your rules to require operators conduct photochemical modeling and dispersion modeling to estimate the effects of OGDP and CAP emissions on short-term exposures to NO2, SO2, particulate matter, and HAPs. Doing so would ensure that your rules address the potential cumulative impacts of oil and gas development rather than simply gather data. Thank you so much for your time.
Thank you, Dr. Weisner. You started your comments as that you are work with the city and county of Broomfield. Are the comments yours personally, or are they on behalf of the city and county of Broomfield elected officials?
They are on behalf of the city and county of Broomfield.
Okay, thank you. Questions? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Dr. Wiesner. Sorry. Could you tell me if you have any RBUs that are within 2,000 feet of this location, or how close any residents in Broomfield might be to this location?
Thank you, Commissioner McGowan. We do not have any RBUs within 2,000 feet. I think our closest residence it's over 3,000 feet.
Okay. Thank you for your testimony today.
All right. Now then, I believe we will move back to the applicant's presentation, and we need to swear in 2 witnesses, I think.
Thank you, Chair. We have our full panel on. And so if everyone could now please turn their cameras on, we can do the swearing in.
Okay, so we're swearing in all these people or just 2? Maybe I got that
All
wrong.
of these people. Thank you.
All of these people. Okay.
Yes.
Let's start some swearing, Ms. Mercer.
Thank you, Mr. Chair. So members of the panel, I'll just go one by one in the order I see on my screen, and I'll be asking each of you to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Ms. Coleman. You're on mute.
I, Julie Coleman, swear to tell the truth. Thank you.
Thank you. Mr. Hess? We can't hear you, sir. Still seem to be muted. Mr. Hess, I'll keep moving down the line and come back to you while you sort out your audio. Mr. Reimer?
I swear to tell the truth.
And could you state your name for the record, please?
Joseph Reamer, and I swear to tell the truth.
Thank you. Ms. Eichenberger?
My name is Julia Eichenberger, and I swear to tell the truth.
Thank you. The next name I'm seeing as Loudney. Sir, if you could raise your right hand, state your full name, and that you swear to tell the truth. And you're on mute.
Nick Loundigan, swear to tell the truth.
Thank you. Mr. Altenberg?
Corey Altenberg, I swear to tell the truth.
Thank you. Ms. Colling? Oh, we can't hear you. Seems like maybe you have a double mute situation happening if you're also muted on your phone or microphone. I'll keep going and give you a minute there. Mr. Nelson?
Justin Nelson, I swear to tell the truth.
Thank you. Ms. Madrid?
Stephanie Madrid, I swear to tell the truth.
Thank you. Mr. Little?
Andy Lytle, I swear to tell the truth.
Thank you. Mr. McCain?
Graham McCain, I swear to tell the truth.
Thank you. Mr. Rader?
Anthony Rader, I swear to tell the truth.
Thank you. Mr. Honus? Oh, we can't hear you either, sir. I'll keep moving forward and come back to you. Actually, I believe that was, or no, Mr. Schlichtenmeyer?
Chad Schlichtenmeyer, swear to tell the truth.
Thank you. Scanning to see who is left here. Mr. Nelson, have I already sworn you in? Okay. All right, and who were we coming back to here? Sorry, I didn't do a great job of keeping track. It looks like folks maybe left and rejoined. Or if any of the panelists still need to be sworn, then you could just speak up and let me know.
Chris Honus, am I coming through now?
Yes,
Yes.
you are. Thank you.
Chris Honus, I swear to tell the truth.
Thank you. I believe there should be one or two more.
I believe Miss Calling and Mr. William Hess. They may need to rejoin the Zoom, so
okay.
May need to give it a minute, or I'm also happy to get started.
Why don't you get started, Ms. Weslinky, and then if and when they choose to testify, we can take care of them at that point in time.
Sure. Miss Calling is presenting today. So Ms. Mercer, I suppose I defer to you if she needs to be sworn in prior to presenting the PowerPoint, or maybe we could do it before Q&A.
If she's speaking, then yes, I think we should have her sworn in before she begins that. And she'll need audio either way, so we should be able to.
She will. Yes. Why don't we at least get our PowerPoint up, if that's okay? I'm just waiting for Ms. Calling to rejoin the hearing. And I do have some introductory remarks. Oh, actually, William Hess is on. So, Mr. Hess, if you could show your camera.
Yeah, can you guys hear me?
Yes.
We can.
Okay. You want? I, William Hess, swear to tell the truth.
Thank you. Looks like we're still waiting for Ms. Calling. If you'd like to proceed, Ms. Wazelinski.
Absolutely. Yes. Why don't I start with my introduction? Ms. Calling is rejoining the meeting. And before she starts, we just may need to pause, but I will get started. So we are still in the morning. So good morning again, commissioners. My name is Kelsey Wazelinski with Jost Energy Law. And with Jamie Jost, we represent Kerr-McGee in the Lizzie OGDP before you today in docket 2212-00350. We would like to thank Mr. Svoboda and the City of North Glen for their efforts and support of the Lizzie location through the USR process, and also ECMC staff and the director for their efforts on this OGDP. We would also like to acknowledge the public comments presented by the City and County of Broomfield this afternoon. As a brief background, Kerr-McGee notified Broomfield of the Lizzie OGDP because the county owns mineral interests adjacent to the proposed Lizzie unit, and because Kerr-McGee is seeking reduced subsurface setbacks on the boundaries of the unit, notification to the county was required under Rule 504. I will reiterate that Broomfield is not approximate local government for this OGDP, and the working pad surface is approximately 3,700 feet from the Broomfield County line. Kerr-McGee did have the opportunity to meet with Dr. Weisner and Broomfield's council in June to discuss Broomfield's comments on Kerr-McGee's air monitoring plan for this OGDP. Kerr-McGee appreciates that conversation and dialogue with the county. During the June meeting, Kerr-McGee walked through its air monitoring plan associated with the Lizzie OGDP and answered the county's questions. Kerr-McGee's air monitoring plan has been approved by the CDPHE, and the team on the hearing today is happy to answer any additional questions on this plan. So if the commission would like Kerr-McGee to address the issues raised by Dr. Weisner today, we're happy to address those at the end of the presentation. Next slide, please. I'll take just a few minutes to summarize the Lizzie OGDP and requested relief before I turn it over to the Kerr-McGee team. This OGDP requests that the commission establish an approximate 2,560 acre drilling and spacing unit to develop 25 new horizontal wells in the Sharon Springs, Niobrara, Fort Hays, Codell, and Carlisle formations. The Lizzie OGDP also requests that the commission approve a 2,560 acre OGDP and one new Form 2A for the Lizzie 8-36HZ location for the development of 25 new horizontal wells. As indicated by Mr. Svoboda, the Lizzie location is within the City of North Glen, and the city approved the USR at a city council hearing on Monday, September 25th, 2023. The team today will provide an overview.
No, it's working.
The team here will provide an overview of the City of North Glen USR process and the September 25th hearing in the presentation today. This OGDP does not trigger any Rule 304 ALA criteria, and specifically the Lizzie location is over 2,000 feet from residential building units and high occupancy building units, over 2,000 feet from all schools and childcare centers, and not within any high priority habitat. Kerr-McGee will walk through the BMPs it has committed to for the Lizzie location, and will address a few commissioner questions about produced water takeaway, fracking engines, and power on the production site. As part of the Lizzie OGDP, Kerr-McGee has committed to plugging and reclaiming 36 wells within 1 year of all new wells turning on to production and decommissioning 8 facilities. Kerr-McGee will describe the associated emissions reductions in the presentation today. And finally, Kerr-McGee has complied with all notice requirements for the Lizzie OGDP. No formal petitions were filed and no public comments were submitted on the Form 2A. I will take just a moment here to address a prior commissioner question on CDPHE consultation. CDPHE was notified of the OGDP and received both the completeness notice and the hearing notice, and CDPHE did not request consultation. There are no RBUs within 2,000 feet of the proposed location, and there's no CDPHE consultation trigger generally for the non-attainment area. Kerr-McGee will present testimony today about the protective BMPs included on the Form 2A to avoid, minimize, and mitigate potential impacts. And with that, let's see if Ms. Calling is able to join with audio under the name of Stephanie Madrid, but we see you, Ms. Calling, and we could swear you in.
Can you hear me okay?
Yes.
Great. Sorry about that. Mix up, everybody. I'm ready. My name is Tracy Calling. I swear to tell the truth.
Thank you.
Great. Thank you, Ms. Wazelinski. Good afternoon, Chair Robbins and Commissioners. I apologize for my computer errors. Hopefully everything will go smooth now. Thank you for your time today. My name is Tracy Calling, and I am a regulatory advisor for Kerr-McGee Oil and Gas Onshore LP. I appreciate the opportunity to present our proposed Lizzie OGDP to you today. Our presentation, we will cover a variety of topics related to this OGDP, including best management practices, surface locations, air monitoring, and community outreach, among other topics listed here. To provide a brief background, Kerr-McGee Oil and Gas Onshore is a subsidiary of Oxy USA Inc. and is one of the largest producers of oil and natural gas in the DJ Basin. Over the past 5 years, KMOG has drilled over 1,400 new horizontal wells and retired and plugged and abandoned over 3,200 older vertical wells. We are proud to have achieved zero routine flaring in not only our Colorado, but all of our onshore operations, including New Mexico, Wyoming, and Texas. This is just a small part of our commitment to reduce greenhouse gas emissions in Colorado. Our Oxy Low Carbon Ventures subsidiary is leading the way in transformational and substantial business models that use human-made CO2 emissions in new ways. We bring over 50 years of carbon management experience by permanently storing approximately 20 million metric tons of CO2 annually. Next slide. Now I'd like to talk a little bit about the surface location for the Lizzie pad. As previously stated, this OGDP consists of just one pad location, the Lizzie 8-36 HZ location, which will develop 25 new horizontal wells. The location is in the city of North Glen, just west of Colorado Boulevard and between County Roads 2 and 4. The North Glen regulatory process includes a robust permit submittal, including setback requirements, zoning considerations, and substantial BMPs as indicated by Director Swoboda, and compliance with air modeling requirements. KMOG received approval from the Planning Commission for the recommendation and approval by the City Council on August 1st. Earlier this week, on September 25th, we received approval from the North Glen City Council for this permit. Weld County is the proximate local government, and we received no objections. And this location is over 2,000 feet from residential building units and is outside of high priority habitat, as well as all Rule 304 B2B alternative location analysis criteria. Next slide. Now I'd like to provide a brief background on the North Glen permitting process. As mentioned, Director Swoboda talked a little bit about that, and I'm just going to provide a few more details. As he mentioned, in 2019, North Glen adopted a new oil and gas regulations. They were very substantial. They included BMPs, a BMP document or ordinance, which included 7 different categories and over 250 specific BMPs. We've been meeting with North Glen since the March of 2022, including numerous phone calls and emails and meetings. And this is with the North Glen staff and their consultant who has the background for oil and gas. As mentioned previously, the application was substantial and met the criteria set forth in their Unified Development Ordinance. In many cases, we exceeded those standards. These are outlined at the bottom of this slide. A few criteria for the North Glen oil and gas permit included 9 specific criteria, as well as referrals that were sent out to several agencies. The criteria are listed here and were all deemed complete and resulted in the final approval of the permit. Next slide. The North Glen approval process included public hearings before both the Planning Commission and the City Council. As part of this hearing notice, as part of the hearing, notice was provided to all parcel owners that were within 1,000 feet of the Lizzie property, as well as a notice to the newspaper and signs posted on the property for the meeting information for the hearings. This is standard for all land use applications. The Planning Commission hearing was held on the 1st of August, and that recommendation for approval went to the City Council, and it included 4 conditions that are listed here. And as I mentioned earlier this week, we received approval from the City Council, and it includes those 4 conditions, which we agreed to. Next slide. Now we will move into the permit timeline. Here we show an overview of that timeline. Noteworthy here is there were no comments received during the 30-day comment period, and no petitions were filed prior to the OGDP petition deadline. KMOG has also received the director's recommendation for approval for this OGDP. Next slide. Here we are outlining our phases of operations and planned timeline. We would like to start pad construction in October of this year, and we hope to work through various phases and begin interim reclamation in the end of 2025. Next slide. Here we're showing our proximity to receptors. As previously mentioned, the Lizzie location is over 2,000 feet from residential building units and outside ALA criteria. The Lizzie development will be located in an area with compatible surrounding and future land uses. To the west is the North Glen Wastewater Treatment Facility, and to the north is the North Metro Fire Rescue District Complex. Both are considered compatible uses. They're non-residential uses, and they're compatible with oil and gas. In addition, the North Glen Comprehensive Land Use Plan identifies this area to be developed as commercial and light industrial. Both of these land uses are considered to be compatible with non-residential uses. Next slide. This location is not within high priority habitat for wildlife. Surveys were completed in 2021 and 2022, indicating that there were no environmental concerns. There is a potential for burrowing owls, and the location was surveyed and nothing was found. We will survey again 2 weeks before we start construction on the location. As shown in this aerial, there is a large body of water to the west. This is the North Glen Wastewater Treatment Facility. This body of water is called Bull Reservoir, and it holds the water that has been treated by the wastewater treatment facility. This reservoir is uphill from our proposed location. The dam for the reservoir is approximately 37 feet higher than the Lizzie pad. Next slide. Beneficial impacts. We will be decommissioning many nearby existing oil and gas wells as part of our beneficial impacts plan. Our KMOG will plug and abandon 36 wells and 8 production facilities will be decommissioned as part of this development. 25 of these wells are within the Northland city limits. This work will include the reclamation of approximately 15.2 acres. The proposed Lizzie site at interim reclamation will be approximately 7.2 acres. So this will result in a net overall reduction of oil and gas development of 8 acres, as well as the reduction of the associated well emissions listed on this slide. We have included this information in both the cumulative impacts plan and the permit Form 2B. Next slide. Listed here are a few of our industry-leading best management practices. Our water on demand system uses underground pipeline that brings fresh water onto the location for hydraulic fracturing. This will eliminate over 120,000 truck trips. Our oil tankless facility design uses pipelines instead of trucks to transport oil to a processing facility. This will eliminate approximately 67,000 truck trips. Our integrated operations center provides remote monitoring capabilities and 24 hours a day, 7 days a week. To avoid odor and emissions, we will be using Group 3 drilling mud and a closed loop system for completions operations. We have the lowest emissions inventory intensity of any oil and gas operator in the DJ Basin, and we have already met the 2030 CDPHE Regulation 22 target. Next slide, please. The BMPs that are listed here are a few of the other BMPs related specifically and requested by the city of Northland for this Lizzie location. And so I'd like to highlight just a few of these. We are proposing an electrically powered production drilling rig. This will be used for this location, which is also a modified drilling rig with noise reduction features. The completions operations will be using a Tier 4 or better frac engines. We will be using a quiet completions fleet, and we are proposing a full wrap of mitigation walls. And this was due to some of the guidelines within the City of Northland's BMP document. And then in addition to the other BMPs listed here, I won't go into details on. Next slide. And KMOG worked with local governments in selecting this haul route shown in yellow. All traffic will travel north on Colorado Boulevard up to County Road 6. Both of these are within the jurisdictions of Weld County. We will be utilizing an existing access point onto Colorado Boulevard, and we have secured an access permit approval through the Weld County Public Works Department. As part of this review, we are also evaluating produced water pipeline takeaway for this location. The nearest disposal well is approximately 4 miles to the east and would require over 25 acres of surface disturbance, including the crossing of 2 irrigation ditches, Big Dry Creek Reservoir and its associated floodplain, as well as high priority habitat for native aquatic species. For these reasons, our evaluation includes that the impacts of piping produced water are greater to sensitive receptors in the area, and we've decided not to do piping of produced water for these reasons. Next slide. Next, I would like to provide an overview of our robust air monitoring program. Since 2022, KMOG has used its field-wide air monitoring program to perform air monitoring at 19 different production drilling sites, 27 completion sites, and 15 different production facility sites, giving us thousands of data points to evaluate any potential impacts from our operations. The resulting data includes 7,500 air samples spanning all phases of oil and gas development. As a result, all are well below the CDPHE health guidance value, which is the orange line on these two charts, of 9 parts per billion for benzene, as shown in the graphs below. Next slide. The air monitoring program for the Lizzie plant includes continuous VOC analyzers and continuous benzene monitoring. Our integrated operations center oversees air monitoring programs, providing immediate investigation response. The site-specific air monitoring plan for Lizzie was approved by CDPHE on August 14th of 2023. Air monitoring will be conducted during drilling and completions operations and the first 6 months of production. The map on the right shows the proposed air monitoring locations around the Lizzie location and their position relative to the nearest residential building unit, which is 2,176 feet to the north. At the end of each month, we will provide a summary of the data collected, and we will send that to CDPHE, the ECMC, and the City of Northland, as well as it will be posted on our stakeholder website listed at the bottom of this slide. Next slide. And finally, as you know, we have a stakeholder relations team since 2014 as a dedicated resource to proactively working with nearby community members. We seek feedback from stakeholders to tailor our operations. KMOG will provide regular updates on projects on our website. Due to the nature of this location and the fact that there are no RBUs within 2,000 feet, we did not get a lot of response. There was 194 community consultations package sent, in addition to notices that were provided through the local permitting process. And were required, mailings were sent out to property owners, signs and postings were placed on the property, and newspaper notifications to solicit participation in the local government hearings. Despite all these things, no comments have been received by our stakeholder relations team. Next slide. In summary, the Lizzie OGDP has had no petitions filed, provides protections to public health, safety, welfare, and the environment and wildlife resources. Kerr-McGee has local disposition from the City of Northland, and the best management practices have been used to avoid, minimize, and mitigate temporary impacts to the community and the environment. KMOG's facility design, innovated with coupled with older facility removal, minimizes its cumulative impacts. KMOG will be plugging and abandoning 36 wells and removing 8 production facilities, reclaiming approximately 15.2 acres, approximately 8 acres more than is being disturbed as part of this OGDP. That is all I have for now, and so I'll turn this presentation back to Ms. Wesselinki. Thank you.
Thank you, Ms. Calling. This slide shows the relief requested for the Lizzie OGDP and associated drilling and spacing unit. This does conclude our presentation, and we are open for any questions.
Great. Thank you for the very thorough presentation that you provided to us. Questions from commissioners? Told you it was thorough. All right, seeing no questions, we move into a deliberation type stage for commissioners. Does anyone desire to lead off with deliberations? Commissioner Cross.
Thank you, Mr. Chair. And thank you for the presentation today. I also want to highlight that I thought it was very thorough. I appreciate representatives from Northland being here to talk about this and the efforts that they undertook, especially since it's somewhat new to Northland. I'm in favor of approving this application. You know, I think the litany of steps that Oxy is taking with respect to this application, as well as the majority of applications we see from them, is exactly the kind of efforts we want to see from operators promoting responsible development. To me, the things that really stick out in this relate to cumulative impacts. And I think when you look at the net benefits that we get from this, just some of the highlights that I wrote down here, you know, bringing back more than 8 acres of land, reducing 10 produced water tanks, 22 oil tanks, 17 condensate tanks, reductions in NOx and VOCs and carbon monoxide and benzene, and less truck traffic. I mean, these are exactly the kind of things that we want to be seeing from operators. I know that we have cumulative impacts rulemakings coming up, and I know this is something that we've talked about in some of the listening sessions as well, that we are taking a lot of steps, and I know the operators are taking a lot of steps to reduce cumulative impacts from operations. And I think when you're seeing these kind of net benefits that we're getting from operators and proposals like this, I think it's something to be proud of. And yeah, I'll be in approval of this application.
Thank you, Commissioner Cross. Others with deliberative thoughts? Commissioner Messner, then Commissioner McGowan.
Go ahead, Commissioner McGowan.
Commissioner McGowan.
Thank you, Mr. Chair. And I agree with Commissioner Cross. I think this was well done, well laid out. I'm also very appreciative of the thorough process that the city of North Glen went through with this planning commission first and then the city council. So I think that this was thoughtful. I like the offsets. I think it was thoughtful from an emissions perspective, and I think this is an approvable permit.
Commissioner Messner.
Thank you, Mr. Chair. I don't have much to add from my other commissioners. I think oftentimes applicants hear me be pretty critical of applications. And I think in this particular situation, there's a lot of good that this application has presented. And I really want to applaud the local government for the thorough review process that they went through in determining how best to site this location within their jurisdiction and the significant process that went through that include opportunities for public comment from local residents within their jurisdiction in multiple occasions, which I think can be really beneficial in ultimately determining the necessary protections for an application like this. I love the fact that this is located in an area that is compatible with other non-residential uses, which is a really appropriate place to put oil and gas developments, in land use planning. And I think that's really well done. And so I applaud North Glen for their process. I also just want to reiterate that 36 wells P&A'd, 8 production facilities retired and removed, and 20 are within the jurisdiction of North Glen. Net reduction of 8 acres of surface disturbance, electric rig, tier 4 completions, air monitoring, distance from RBUs, in an area that is compatible with non-residential uses like light industrial and other things like that. To me, this is a great example of how to appropriately locate oil and gas development and minimize and mitigate, avoid, minimize, and mitigate impacts. And so I am in approval of this application.
Appreciate those thoughts, Commissioner Messner. Commissioner Ackerman.
Thanks, Mr. Chair. Nothing different to add. I only would just state that I talked often about the intent of Senate Bill 181, and it was a significant step forward in increasing the standards of oil and gas development in Colorado. And OGDPs have responded by upping the standard of OGDPs. I very much appreciate this operator by their efforts to not just meet those standards, but to work with us to incorporate the spirit and intent of Senate Bill 181 and ask themselves questions about where they can improve their standards to most adequately protect the people of Colorado and its environment, and very much appreciate those efforts, and also agree that this is certainly an approvable OGDP.
Great. Thank you, commissioners, for your comments. I don't have a whole lot to add. I am in agreement with everything that's been said. I do also appreciate the city of North Glen's review. And I appreciate Oxy's working with the city of North Glen. I think you found a really appropriate spot that meets with the city's zoning and compatibility standards. And I think that is well done. And again, a very thorough presentation. Do we have a motion?
I'll move approval of this OGDP.
Second.
We have a motion and a second. Is there further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. The OGDP is approved. Thank you very much. Commissioners, we've got one more docket. It is close to 12:15. I would be in favor of a 30-minute break to grab some lunch, and then we can finish up this afternoon if folks are comfortable with that. Let's do that. Let's return at 12:45. All right, welcome back. This is the Colorado Energy and Carbon Management Commission. It is Wednesday, September 27th. We are undertaking our business agenda, and it is 12:45. The next docket is docket 2209-00251, an oil and gas development plan. Kier McGee Oil and Gas Onshore LP, operator number 47120 is the applicant. And Ms. Wazlinki is with us to present. I think we'll start, Ms. Wazlinki, with if we have him, we could start with Jason Maxey, and then we could then swear in your witnesses and then proceed with your case in chief. Is that okay?
That sounds great.
Thus, I am looking to see if we have Jason Maxey. Good afternoon, Mr. Maxey.
Good afternoon, Chair Robbins and commissioners. Thank you for the brief pause while I was being elevated to the panel. I appreciate it. And as always, always appreciate just a few minutes to come before you to speak for just a few minutes regarding the Weld County 1041 WOGLA process, and today specifically Kier McGee's Labrisa OGDP that is in front of you for consideration. My name is Jason Maxey, the director for the Oil and Gas Energy Department for Weld County. Weld County has an assigned 1041 WOGLA number to this location already. That is 1041 WOGLA 22-0036. For the record, the Oil and Gas Department held a pre-application meeting for the Labrisa location last year, June 15th of 2022. There were several alternate sites that were discussed as per our normal process, which you all are aware of. Attendees to that meeting included Kier McGee staff, along with Weld County staff. CPW also attended, and ECMC staff did as well. We also invited the town of Hudson due to their proximity to this location, and a representative from the town of Hudson did attend that pre-application meeting. We submitted our 2A comments to the ECMC on August 23rd of 2023, and I believe those are included in the director's recommendation. Our 1041 application was received on October 11th of 2022. It's important to note that through the 1041 WOGLA process and the notifications and the referrals that we send out to various agencies, Weld County did not receive any public comments during that application period, and we also did not receive any requests to participate in our hearing. We held our hearing on February 2nd, 2023, and it was subsequently approved by Weld County's hearing officer after that hearing was concluded. The final order, as per our rules state, was recorded with the county clerk and recorder, and then was officially noticed in the Greeley Tribune on February 17th of 2023. I do want to just remind the commission and just call out a few things. Maybe you saw this in some of the drawings, but regardless of I guess, any of the aforementioned items that I just said, I do want to call out a couple of things that regarding Weld County's process and the fact that remind the commission that we are a little bit stricter in some things than the ECMC. And a couple things that I think are worthy to point out. You will find that at the end of this short presentation here, short discussion, we're proud to recommend approval of this, and we agree with the director's recommendation for approval to you all. But Weld County takes a little bit deeper look at a few things, even in an area like this, to where there are no culturally sensitive items around the area or within 2,000 feet. I've been online all day and I've listened to the North Glen location and listened to some of the input from surrounding jurisdiction. And so I just wanted to point out to the commission just to, again, I guess, talk about the robustness of Weld County's local land use process and how proud I am of our process and how proud I am of our relationship with operators such as Oxy, who go above and beyond and do a good job when looking at siting these locations. Our definition of a building unit, as well as our definition of what an oil and gas location includes and the area that's included in that location, is more strict than the ECMC's rules. You might have seen in the drawings submitted with this application, we classify one building unit within 2,000 feet of the location. However, I do want to call out that this is a commercial use, and so it is not a building unit per the ECMC's rules, because it's not residential in nature. And furthermore, the commercial use is the same landowner as the subject property for the Labrisa location anyways. And in addition, I know that in your director recommendation, it was called out that there is no alternative location analysis needed for this application due to nothing being within 2,000 feet. But I just wanted to remind the commission, it's been a while since we've talked about these and gone over Weld County rules, but Weld County does handle alternative siting for all applicants and for all permits, regardless of anything that's within or outside of 2,000 feet. That's just a part of our normal process. So again, I'm proud of our process. I really appreciate being able to be in front of you for a few minutes to talk about this Kerr-McGee-La Brisa application. And again, would agree with your director's recommendation, and we would fully support approval of this permit for Kerr-McGee. Thank you very much. Happy, as always, to answer any questions you might have.
Thank you, Mr. Maxey. As always, we appreciate Weld County's involvement in our process, our involvement in your process, and the collaborative working together on these matters. I think we've established a pretty good working relationship, and we appreciate your thoughts about this particular location and the work that you did on it. Are there any questions for Mr. Maxey from commissioners? All right, we'll let you go back to your day job, and I know how to reach you if something comes up. But again, thank you for your time this afternoon.
Thank you, Chair Robbins and commissioners very much. And Chair Robbins, I concur with the comments you made just a second ago regarding our working relationship. So thank you for that. And I look forward to seeing you all soon. Thank you.
Very good. All right, Ms. Wazelinki, do you want to elevate your panelists so that we can get them sworn in?
Yes, thank you, Chair. We've got our entire panel on the hearing. So if everyone could please turn on their cameras. Thank you.
Point of order, AG Mercer. If this is the same panel that was sworn in last time, is there any way that we could just sort of like acknowledge that they've already been sworn in once for a hearing today?
Yes, Mr. Chair, I think that's fine. I would just advise all of the panelists that you remain sworn in and that you remain obligated to tell the truth. I'd also just check with Ms. Wazelinki whether there are any members of this panel that were not on the first one.
Thank you, Ms. Mercer. There were a few. So perhaps those of you who have not been sworn in could keep your cameras on, and those who have already been sworn in could turn their cameras off.
Okay.
That's right.
Look at these efficiencies we're creating.
Yes, appreciate the assist from Mr. Chair and from Ms. Wazelinki. So for the remaining members of the panel, I'll go one by one in the order that you appear on my screen. And I'll just ask you to raise your right hand, state your name, and say that you swear to tell the truth. Ms. Friedman?
Rachel Friedman, I swear to tell the truth.
Thank you. Ms. Hess?
Margaret Hess, I swear to tell the truth.
Thank you. Mr. Porter?
Thomas Porter, I swear to tell the truth.
And Mr. Walker?
Trevor Walker, I swear to tell the truth.
All right. Thank you to all of the panelists.
And Ms. Wazelinki, in order to possibly create even more efficiencies, I know that your clients generally speak to kind of overall as a company, the good stuff they do. It's the first 2 or 3 slides. We'll take judicial notice of that if you want to. If you want to go through it, that's fine too. It's your case, but just wanted to throw that out there.
Thank you, Chair. We anticipated that and will not be doing a second round of review of that material.
Excellent.
Okay, well, thank you. I think we'll start with just bringing our PowerPoint up. Okay, wonderful. Well, good afternoon again, commissioners. My name is Kelsey Wazelinki with Jost Energy Law, and with Jamie Jost, we represent Kerr-McGee in the La Brisa OGDP before you today in docket 2209-00251. We would like to thank Mr. Maxey and Weld County for their efforts in support of the La Brisa location through the WOGLA process, and also ECMC staff and the director for their efforts on this OGDP. Next slide. So this OGDP requests that the commission establish an approximate 1,280 acre drilling and spacing unit to develop 10 new horizontal wells in the Sharon Springs, Niobrara, Fort Hays, Codell, and Carlisle formations. The La Brisa OGDP also requests that the commission approve a 1,293.45 acre OGDP and 1 new Form 2A for the La Brisa 11-35HZ location for the development of 10 new horizontal wells. As indicated by Mr. Maxey, the La Brisa location is within Weld County, and the WOGLA was approved in February of 2023. This OGDP does not trigger any Rule 304 ALA criteria, and specifically the location is over 2,000 feet from residential building units and high occupancy building units, over 2,000 feet from all schools and childcare centers, and not within any high priority habitat. Kerr-McGee will walk through the BMPs it has committed to for the La Brisa location, as well as Kerr-McGee's commitment to plug and reclaim 3 wells within 1 year of all new wells turning on to production and decommissioning 3 facilities. Kerr-McGee will describe the associated emissions reductions in the presentation today. And finally, Kerr-McGee has complied with all notice requirements for the La Brisa OGDP. No formal petitions were filed, and no public comments were submitted on the Form 2A. And with that, I'll turn it over to Rachel Friedman with Kerr-McGee to continue the presentation.
Thank you, Ms. Wazelinski. Good afternoon, Chair Robbins and Commissioners. My name is Rachel Friedman. I'm a geological advisor with Kerr-McGee Oil and Gas Onshore LP. I appreciate the opportunity to present our proposed La Brisa OGDP today. I would like to thank Weld County and ECMC staff for their involvement in this process, as well as staff from the town of Hudson. In our presentation, I'll cover a variety of topics, including BMPs, air monitoring, and community outreach. Next slide, please. We can skip this slide. Thank you. Listed here are a few of our industry-leading best management practices. Our Integrated Operations Center provides remote monitoring capabilities 24 hours a day, 7 days a week. Our water on demand system uses underground pipelines to bring water onto location for hydraulic fracturing. At the La Brisa location, this will eliminate over 51,000 truck trips. Our oil tankless facility design uses pipelines instead of trucks to transport oil to a centralized processing facility. This will eliminate over 44,000 truck trips associated with this OGDP. We have the lowest emissions inventory intensity of any oil and gas operator in the DJ Basin and have already met the 2030 CDPHE Regulation 22 target. To avoid odor and emissions, we'll be using Group 3 drilling mud and a closed loop system for completions operations. Next slide, please. This slide shows an overview of our permitting timeline. I'd like to note that no comments were received during the 30-day comment period and no petitions were filed to the OGDP. Kerr-McGee has also received a director's recommendation for approval of this OGDP. Next slide. This OGDP consists of one location, the La Brisa 1135 HC, which will be used to drill 10 new horizontal wells that will develop 1,280 acres. The pad is located in unincorporated Weld County, north of I-76 and the town of Hudson. Kerr-McGee received an approved 1041 WOGLA from Weld County on February 2nd, 2023. The proximate local government, the town of Hudson, has not expressed any concerns regarding this development. The location is outside of all Rule 304 B2B ALA criteria. It is more than 2,000 feet from any RVUs or high occupancy building units, outside of high priority habitat, further than 1,500 feet away from designated outdoor activity areas, and over 2,000 feet from schools and childcare centers. The La Brisa location is not within a floodplain nor immediately upgradient from wetlands or riparian areas, and there are no disproportionately impacted communities within 2,000 feet of the proposed pad. Next slide, please. This is an outline of our phases of operations and planned timeline. We'd like to start pad construction in October of this year and hope to work through the various phases and begin interim reclamation in January of 2025. During the pre-production phase, the pad will be 13.45 acres and will be reduced to 3.5 acres for the production phase. Next slide, please. Current and anticipated future land use in the surrounding area is compatible with the proposed La Brisa development. The surface owners of the proposed location also own and operate the poultry farm to the east. The office for the farm is considered a non-residential building unit and is located 1,874 feet to the east of the working pad surface. The nearest residential building unit is 2,350 feet to the east and is used to house a Sparbo Farms employee. According to the surface owner, the second RBU shown on the map is currently vacant. Kerr-McGee has worked with the Sparbo Farms owners to confirm that their tenant and workers are aware of our proposed operations. Next slide, please. This location is not within high priority habitat. Inspections were conducted in both 2022 and 2023. Potential burrowing owl habitat is present in the area, and as such, the location will be surveyed prior to starting construction. There is no wetland vegetation within 500 feet of the working pad surface, and no environmental concerns were noted by our biological experts. Next slide. Highlighted on the map, you'll see the 3 wells that Kerr-McGee will plug and abandon. We will also reclaim 3 production facilities near the La Brisa development. This work will include the reclamation of 5.6 acres of existing pads. The proposed La Brisa site at interim reclamation will be approximately 3.5 acres. This results in a net overall reduction of approximately 2 acres of pads in the area. When access roads, pipelines, and utilities are considered, the development will reclaim just 0.84 more acres than is permanently disturbed. Removing older facilities will eliminate 256 annual truck trips in the area, and emissions reductions associated with plugging older wells and removing their facilities is shown in the chart on the left. Next slide, please. This slide shows a summary of our BMPs that will be used at the La Brisa location. A few I would like to highlight include rig power that will be supplied by natural gas engines and a battery energy storage system. Completions operations will be conducted with a quiet completions fleet and use Tier 4 equivalent or better engines. We will place a sound wall on the east side of the location during completions to mitigate noise. Next slide. Lighting will be angled away from surrounding receptors. Vehicles will be limited to 10 miles per hour on the access road to limit dust. Kerr-McGee worked with the town of Hudson and Weld County when selecting this haul route that is shown in yellow. All traffic will utilize an existing access point and then travel south on North Oak Street to the I-76 frontage road. We have secured a right-of-way permit from the town of Hudson for use of this haul route. Next slide. Since 2020, Kerr-McGee has used its field-wide air monitoring program to perform air monitoring at 19 different production drilling sites, 27 different completion sites, and 15 different production facility sites, giving us thousands of data points to evaluate any potential impacts from our operations. The resulting data includes 7,500 air samples spanning all phases of oil and gas development. All results are well below the CDPHE health guidance value of 9 parts per billion for benzene, as shown in the graphs below. Next slide. The air monitoring program includes continuous VOC analyzers and continuous benzene monitoring. Kerr-McGee's IOC oversees the air monitoring program, providing immediate investigation response. The site-specific air monitoring plan for La Brisa was approved by CDPHE on May 16, 2023. Air monitoring will be conducted during drilling and completions operations and the first 6 months of production. At the end of each month, we will provide a summary of the data collected to CDPHE, ECMC, Weld County, and post the information to the Oxy stakeholder website. The map on the right shows the proposed air monitoring locations around the La Brisa location and their position relative to the nearest RBU. Next slide, please. We have had a stakeholder relations team in place since 2014 that is a dedicated resource to proactively work with nearby community members. As part of our engagement, Kerr-McGee has provided all required notices, including 100 completeness packets. In response to our mailings, 4 stakeholders reached out with questions regarding their mineral interests. Kerr-McGee provided information to the owners of the Sparrow Farms and offered to hold an in-person meeting with their employees. Our stakeholder relations team is a resource for the community for the life of the facility, from the planning stages through the final reclamation of the wells. We are available through any form of communication the stakeholder prefers. All project updates will be posted on our website in addition to the monthly air monitoring summaries. During pre-production activities, our response line phone number and email address will be posted at the entrance of the access road so that we are easily reached. Next slide. In summary, the Labrisa OGDP has had no petitions filed, provides protections of public health, safety, welfare, the environment, and wildlife resources. Kerr-McGee has received local disposition. The best management practices we have proposed will avoid, minimize, and mitigate temporary impacts to the community and the environment. Kerr-McGee's innovative facility designs, coupled with older facility removals, will minimize its cumulative impacts. Kerr-McGee will be plugging and abandoning 3 wells and removing 3 facilities. We will reclaim approximately 5.6 acres, which is 0.84 more acres than will be disturbed by this OGDP. Thank you very much for your time this afternoon. I'll hand it back to Ms. Wazelinski now.
Thank you, Ms. Friedman. This last slide shows the requested relief for the Labrisa OGDP, and we respectfully request your approval of the OGDP and associated drilling and spacing unit. And this concludes our presentation.
Great. Thank you very much for a very thorough presentation once again. We appreciate it. Commissioners, do we have questions for the panel? Commissioner Cross?
Thank you, Mr. Chair, and thank you for the presentation. I just wanted to follow up on one of the questions. In the slide talking about the community outreach, you mentioned that there was some questions regarding mineral interest. I just want to make sure that everything was resolved with those questions, and also if there was follow-up questions related to anything else from those stakeholders.
Absolutely. I'm happy to jump in here. My name is Margaret Hess. I work on the stakeholder relations team. All of the mineral calls came through our response line and were questions about why did I get this mailing and what does it mean for me? So they were all positive, no follow-up questions, all positive.
That was the only question I had.
Other questions for the panel? All right, seeing no further questions, once again, I think it's a testament to the thoroughness of the review by Oxy and our staff. We will move into deliberations and/or motion. Mr. Cross.
Thank you, Mr. Chair. I will move for approval of this application. My only deliberative comment is, I guess I was disappointed that there's just not as much reduction as the last application I saw. But in all seriousness, I think that, again, we're seeing net benefits across the board here. And even where electrification wasn't possible here, it's great to see that they're doing natural gas engines, they're doing the battery energy storage system. So I think there's a lot of great things to see here, and I'd move for approval.
Second.
We have a motion to approve with a second. Is there further discussion? Seeing no further discussion, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. Thanks again to staff for the work on this behind the scenes, but it's helpful. And thanks to Kerr-McGee for putting together a good proposal. Appreciate it. Commissioners, I believe that concludes the business agenda for September 27th. Do we have a motion to adjourn?
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
We are adjourned. See you in a bit, folks. Thanks.